May please, Your Worship. With the consent of other side, my lord, I beg to mention item number 8 of today's list, my lord. In this case, my lord, the petitioner has sent the earlier sets of counsels, my lord, and I have been instructed to appear on behalf of the my lord petitioner, my lord. So, my lord, may I pray that the matter may be taken up immediately after the Bihu vacation, my lord, any date, my lord.
Okay, what is your name?
R. Sharma, my lord.
Heard Mr. R. Sharma, and counsel for the petitioner who submits that as he has been newly engaged by the petitioner.
I yet to file Wakalatnama. I will file, my lord.
And he will be filing his Wakalatnama very soon. He needs some time to prepare the case. And he prays for an adjournment. He has also submitted that he has obtained the consent of learned counsel for the.
I'm appealing for respondent.
Two, you don't have any objection.
No.
What is your name?
A. Chetty, Lordship.
Mr. A. Chetri, learned counsel for the respondent number
Two.
Respondent number 2 does not opposes the prayer. Hence, the prayer is allowed. Let this case be listed after 2 weeks.
If Lordship may call me date, may be because.
No date, registry will fix the date.
Because it is a.
Immediately, my lord, then.
That pertains to the non-payment of maintenance.
Yes, my lord. 125 proceedings, my lord. So,
But after 3 weeks, after Bihu,
After Bihu,
25th April,
obliged.
my lord, interim order passed, that may be.
the interim order shall continue till next day.
Hello.
My pleasure, Lordship. Lordship, item number 27. So, after 4 weeks, Lordship, and for here.
27 is 27.
27.
It is tagged with item number 26.
So I am not, Lordship, and another advocate, Lordship, but today we will not conduct this case, Lordship, for a hearing. So let it after 4 weeks, Lordship.
Why? Reason?
Lordship, some personal difficulties, and Mr. B.
Heard
Sir is.
Mr. F. Hawk, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed after 4 weeks.
Lordship.
May it please,
And Lordship, another prayer, Lordship, and the criminal revision petition, Lordship, and the petitioner is convicted 6 months.
Which item number?
No, Lordship, for listing, Lordship. For listing. And 6 month conviction, Lordship, and they approached the Honorable Landed Session Court, Lordship, upheld this earlier order, Lordship.
This is a fresh
Yes, sir.
matter. Fresh matter, new matter.
Fresh.
When have you filed?
Lordship, and already yesterday, Lordship, listed, but due to Lordship, I was on late, it's another court, Lordship, that is why.
No, yesterday's matter will be notified again. That was,
No, Lordship, that matter was called for, but I was not attend this matter, Lordship. So, none else.
listed in my court.
No, Lordship, court number 27.
So you mentioned before court number 27.
But I think, Lordship, senior bench is.
There are more senior benches.
Lordship. Lordship.
May it please, your Lordships. Lordships, I beg to mention item number 10 of today's list. In this matter, the arguing counsel is from Itanagar. She has not been able to come today due to some personal difficulty. So may I pray that this matter may be taken up in the first week of April.
Heard Mr.
S. Vishwakarma.
S. Vishwakarma, who prays for an adjournment on the ground that the arguing counsel, Ms. T. Ginny, is from Itanagar, and she was unable to make it today. And they stop. Considering the submission made by learned counsel, the prayer is allowed. Let this matter be listed after.
Can a date be fixed, since she will be coming?
5th April.
There is an interim, that means
The interim order shall continue till last week.
deeply obliged.
May I Lordship? In making a prayer for a listing of an IM in connection with an MSc appeal. That has been last listed in the month of December, my lord, that IA. So if any date may be on next week, my lord, for orders, that IA may be listed, my lord.
MSc appeal, you pray before registry. Why it is not?
My lord,
You approach registry.
there is some urgency in this case, my lord. There are functionaries who were.
You approach registry. Registry will list.
My lord.
Lordship, I beg to mention item number 16 and 17, Lordship. Lordship, in both the cases,
16 and 17.
16 and 17, Lordship.
What is your prayer?
Lordship, CD has not been received, your lordship.
16 lordship. Charge sheet lordship.
16 has,
Charge sheet lordship.
16 charge sheeted. We'll take it up when the
Lordship.
matter is called for.
Lordship.
May I please, your lordship? I beg to mention item number 39 with the consent from the other side.
Lordship, I am for the petition.
Lordship, we have not received the memo of appeal today. Okay.
Heard Miss,
Somewhere to give you that.
what is your name?
K. Bhattacharya.
K. Bhattacharya, appearing for respondent number 2.
Yes, yes. Sir.
Also heard Miss,
D Deka on behalf of
Deka.
J. Kalita.
appearing for the appellant. The respondent number 2 has prayed for an adjournment on what ground?
We have not received the memo of appeal.
Lordship,
Has submitted that they have not yet received the
which
memo
has been served with within 2 days.
of appeal. The learned counsel for the appellant undertakes to serve the same within 2 days. Stop. Considering the submissions made by learned counsel, let this matter be listed after 2 weeks.
Lordship, a date may be fixed.
No, this
After 3 weeks, lordship.
after 3 weeks, no date,
A date may be fixed.
after 3 weeks.
May I please, your lordship? Lordship, I beg to mention item number 28 of today's list. Lordship, may kindly fix the matter after 3 weeks minus.
Ground for adjournment,
Some difficulty, lordship.
heard Mr.
H.J. Tamuli,
Item number 28,
8th lordship.
heard Mr. S.J. Tamuli, learned counsel for the appellant,
Lordship,
who prays for an adjournment on ground of personal difficulty. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after
3 weeks,
3 weeks.
lordship.
May
Obliged.
may I please, your lordship? I beg to mention item number 22, lordship. Lordship,
Yes,
matter may be adjourned for a day, lordship. The arguing counsel, you Dr. Lordship, went to Lakhimpur for medical urgency. His father, lordship.
heard Mr. What
B.
is your
Datta.
name?
B. Doctor.
Heard Mr. B. Datta, learned counsel for the appellant, who prays for an adjournment on the ground that the arguing counsel is out of station
Out of this.
due to some medical urgency. Considering the grounds, the prayer is allowed. Let this matter be listed after a week.
No, lordship, day after tomorrow, lordship.
After a week.
May I please, your lordship, for listing of a kindred appeal, your lordship, on 26th, your lordship. It was last listed on 1st of March, but it was not reached, your lordship. On 26th of this month, your lordship.
For hearing,
Orders, your lordship.
for,
Yes,
okay,
on 26th, obliged, deeply obliged.
May I please, lordship? Lordship, I beg to mention item 18, lordship.
1A.
Yes, lordship. The conducting counsel, Mr. Fias, health is not well, lordship. CD is available.
Okay, heard Mr.
NZ Chaudhary.
NZ
Chaudhary.
Sohoria, learned counsel for the petitioner, who prays for an adjournment on the ground that conducting counsel, Mr. A.R. Bhuya, is unwell.
Lordship.
Considering the ground, the prayer is allowed. Let
CD
this
is
matter
available.
be listed
CD is available, lordship.
at a date due. On 21,
Interim till then, may be continued.
let this matter be listed on 21.
CD may be retained, that may
The
be.
case diary is available, which may be retained till next date. The interim order shall continue till next day.
Much obliged. 21, Mr.
May
Oh,
I please, your lordship? Lordship, I beg to mention item number 4. Lordship, kindly pass over the matter for the date.
Ground,
Lordship, Mr. A.K. Gupta is not well.
heard Miss B. Sharma. What's her name?
B. Sharma.
Heard Miss B. Sharma. Learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting council, Mr. A.K. Gupta, is unwell. Considering the submissions made by council, the prayer is allowed. Let this matter be listed next Monday, Tuesday, on 27th
Obliged, Lordship.
March.
May I please, your lordship? I beg to mention item number 24 of today's list, as my senior PM Chaudhary is not attending the court, this honorable court today. So I pray that the matter may be taken as per the court convenience.
Heard Miss M. Medhi, learned counsel for the appellant who prays for an adjournment due to the personal difficulty of conducting counsel, Mr. B. M. Chaudhary. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
I beg to mention on behalf of A.K. Purkash, he has developed some back pain.
Item number?
I think 26, my lord. So for today, this adjourn and next week may come.
Heard Mr.
MJ Borua, on behalf of.
M. J. Barua, who submits that the conducting counsel for the petitioner, Mr.
A.K.
A.K. Purkasta, is not well. And on that ground, prays for an adjournment. Stop. The prayer is allowed. Let this matter be listed after a week. After 4 weeks.
My pleasure, Lordship. I beg to mention item number 33 and 34, Lordship. Analogous matter, Lordship. 33 and 34, Lordship, my senior is out of the station. So matter adjourned for 3 weeks, Lordship, after verification.
Heard Mr.
P. Sharma.
P. Sharma, learned counsel for the petitioner. You have informed
Yes, B.
the
Gogoi.
other side
Yes, B. Gogoi, yes, yes.
who have submitted that the conducting counsel, Mr. O.P. Bhatti, is out of station. And on that ground, he has prayed for an adjournment. He has also submitted that he has informed learned counsel for the respondent's side, and who have consented to the prayer made by the learned counsel. Stop. In view of submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks.
Obliged.
May I please? Item number 5, my lord, I may be allowed to introduce this, my lord, because the tested copy is not correct, my lord. Liberty may be given, man.
Heard Mr. S. Thakur, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition on the ground that some typographical, some mistake has crept in the petition. Considering the submissions made by learned counsel, the prayer is allowed. This criminal petition is dismissed on withdrawal with liberty to file afresh if required.
Item number 1.
May I please, Lordship? Lordship, here maintenance petition, maintenance case is filed without following the guideline of Supreme Court, providing
No, repeat, what happened?
maintenance petition, challenging the maintenance case as well as interim order by way of this petition. The maintenance petition was filed without supporting the asset and liability affidavit.
You are challenging the order dated
The order dated
12/9.
12/9/2023.
This is a case under 482 or 401.
This is 482.
It is a revisionable order.
Both,
Both
Can be.
cannot, because there is a question of limitation in, if you come under 401, you should have come
then it will become within
within 3 months, you should have come, and then the question of condoning the limitation is there. So you have to choose. This
Okay.
cannot be a 482 petition.
482, there is no limitation, Lordship.
But this,
It is
when
inherent.
there is a provision for filing revision under this order, you should have come under 401 with a condonation of delay prayer.
Maybe, but 482, this court has inherent power to entertain the matter.
Where there are specific provisions to deal with a particular circumstances, 482 is not applicable. When your case is covered under section 397,
Not only this order, Lordship, I am challenging also the petition also, maintenance case also. For passing of the maintenance case also.
on what ground?
Because when the maintenance case was filed, it was not provided with the affidavit of asset and liabilities, which is a mandatory term at present. The court below has accepted the asset and liability affidavit after 4 months of filing of the case. So this is a question arising whether it was filed along with the affidavit of asset and liabilities. And while considering the interim maintenance, both the affidavit of parties has not been taken care of proper perspective.
Where is your prayer portion?
Fair person is Lordship page number. Page 9, Lordship.
You have prayed only for quashing of.
No, Lordship, in last 12, in connection with MR case number pending before CBDT, as well as quash the proceeding of said MR case number 7 of 2000. Notice me can be. I am paying maintenance, interim maintenance as ordered. I am already paid.
Mr. B. Foucault, learned counsel for the petitioner. This application has under section 482, read with section 397/401 of this Code of Criminal Procedure from 1973, has been filed by the petitioner for setting aside the impugn order dated 12/9/2023 passed by learned Chief Judicial Magistrate Bojali Patshala in connection with MR case number 7/2023. The petitioner has also prayed for quashing the proceedings of MR case number 7/2023. Stop. Issue notice to the respondents. Since learned public was, why have you made PP as a party?
Because
As learned public prosecutor is representing the respondent number 1, no formal notice need to be issued to respondent number 1. As respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD, returnable after 4 weeks. Let this case be listed accordingly after 4 weeks.
Item 2.
May I please have a question? This petition has been filed, send me the impugn order, which is the page, your lordship will find page 26, your lordship, along with the impugn. Been ordered 21 or 24, my lord. That has been passed under section 452 of the Companies Act. Your Lordship will find page 26.
Page number?
26, Your Lord.
Yes.
Yes, whereby, my lord, the petitioner, my lord, the petitioner who is retaining a house, my lord, over a plot of land, was directed by the learned court below to vacate it, my lord, by the impugned order. It is passed under section 452 of Companies Act, my lord, 452. In the interim, my lord, where the case, this complaint, initially the complaint has been filed by the company, my lord, under section 452 of the Companies Act, with a prayer that I have wrongfully retained the property of the company, that is the allotted house, my lord. And in the interim, at the stage of evidence, my lord, this interim application has been filed by the company, seeking a prayer that I may be vacated from the allotted house, my lord.
Okay.
That is the case, my lord. And here in this case, my lord, we are
What is the wrong in the said order?
said order, my lord. It is the basically, my lord, the accused, the section 452, my lord. 452 of the Companies Act.
Putul. Companies Act, yes, Companies Act. No, what is the wrong? What is the error?
Wrong is, my lord, this case, my lord, the petitioner who is, she is a lady, my lord, she is staying in, occupying the plot of land, that is the house over the plot of land, my lord, which has been allotted for ceiling surplus, my lord. That is a government plot of land, government land, my lord. And that is not a property of the company, and they've been enjoying the said plot of land, my lord. This has been like being a legal heir, her husband, it was allotted in the name of her husband, my lord. Your lordship will find allotment, your lordship. Page 34B, your lordship. The allotment letter. Type copy, your lordship will find it at page 34. There is annexure 4.
Page?
Page 34, annexure 4, type copy. The vernacular, your lordship will find that is at page 34B.
This is the type copy of.
This is the type copy of the allotment letter, my lord, which was allotted in the name of my husband, my lord, Dinanath Bora. And the main allegation in the complaint petition is that Dinanath Bora is retained in the quarter of the company and he is not vacating. He expired, my lord. Subsequently, his legal heirs are staying in that particular.
No, why this complaint has been filed under section?
452 of Companies Act. It
What?
says punishment for wrongfully withholding property of a company. This complaint has been filed under section 452, my lord. And the interim application.
This impugned order is an interim order.
Yes, your lord. Again, during the pendency of the CR case, my lord, they have filed this in interim application, my lord. That is, which is under 452(2), my lord. And that was allowed, my lord, directing the petitioner to vacate the land.
So what is your submission?
My submission, your lordship, we are praying for quashing of the impugned order as well as the order taking cognizance in the CR proceeding, my lord. Because the whole case is, my lord, if I read, my lord, section 452, your lordship, it says punishment for wrongful withholding of property, which says if any officer, employee of a company wrongfully obtains possession of any property, including cash of the company, having any such property, including cash in his possession, wrongfully withhold it or knowingly applies it for the purpose other than those expressed or direct in the articles authorized by this act, he shall, on the complaint of the company or by any member or creditor or contributory thereof, be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. In this section, my lord, here it says if any officer or employee of a company, my lord. I am not the officer of the company nor officer or employee of a company.
But your husband was.
Husband was, my lord. He expired in the year 2018, and they have come up with this in the year 2020.
And what is 452 clause 2?
452, may I read, my lord? 452 clause 2 says, the court trying an offence under subsection 1 may also order such officer or employee to deliver up or refund within a time to be fixed by it any such property or cash wrongfully obtained or wrongfully withheld or knowingly misapplied the benefits that have been deprived from such
But
property.
this has to be after trial, after completion of trial.
My lord, this interim application they have filed at the stage of evidence stage, and that was
This 452 clause 2
clause 2, my lord.
is can it be applied in interim? Because you have to come to a finding that it is wrongfully possessed.
Lordship. It is wrongfully, the whole, at the stage of evidence itself, my lord, they have filed that application and they have obtained that order, which frustrated the entire process of adducing my defense also, my lord. I appeared before the learned court below, my lord. Offences were explained to me. I was ready to adduce my defense, my lord, after once the evidence stage is over. But during the at the stage of evidence, my lord, this order has been passed. They have filed an application, my lord. I have annexed it, the interim application as well. That is page 21. This order has been passed at the stage of evidence itself, my lord. To have given a chance, my lord, to reduce our defense, because we understand this land has been the surplus ceiling land, my lord, that has been allotted in the name of my husband. And we've been staying there since decades, my lord. Moreover, my lord will find page 38 also, my lord, there's a report of the circle officer with regarding the status of the land.
So you have a interim prayer also.
Interim prayer, my lord.
We'll hear your prayer after service of notice on the respondent number 2.
The balance of convenience is in my favor, my lord and lordship, because this order is in force, my lord, and the company is pressurizing us to vacate on the in terms of the state order. It is 80 years lady, my lord. Where she will go?
Mr. R.A. Chaudhary, learned counsel for the petitioner, also heard Mr. K. Das, learned counsel, learned public prosecutor appearing for respondent number 2. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Srimati Rumi Bora, who is an 80 years old lady, for quashing the impugned order dated 15/2/2023, passed by learned Judicial Magistrate First Class Nazira Sibsagar. This 15/2 order is.
This is order taking cognizance, madam.
Taking cognizance of taking cognizance of offense against the petitioner under section 452 of the Companies Act 2013. The petitioner has also prayed for quashing the order dated 24/1/2024, passed by learned Judicial Magistrate First Class Nazira in the aforementioned case whereby the interim prayer of the complainant within bracket respondent number 1 under section 452 clause 2 of the Companies Act 2013 was allowed, whereby the present petitioner was directed to vacate the quarter allotted to the husband of the present petitioner. So, learned counsel for the petitioner has submitted that a proceeding under section 452 of the Companies Act 2013 is maintainable only against an officer or an employee of a company, whereas the present petitioner is neither the officer nor an employee of the respondent number 1 company. It is also submitted by learned counsel for the petitioner that where is the allotment order?
Allotment order, your lordship will find it at page, it is 34B, my lord, the vernacular.
That the land over which the petitioner is presently residing in her
Annexure 4,
house has been allotted to
her husband,
her
Dinanath
husband, late what is the-
Bora.
Dinanath Bora, by the government of Assam. And in support of these submissions made by learned counsel, the allotment. Where is the vernacular?
Vernacular is page 34B, my lord, Annexure 4.
Vernacular is annexure.
Annexure 4, your lordship.
Annexure 4 is the type copy.
Annex, yes, your lordship, series 34B, your lordship, page 34B. 34 is the type copy, and vernacular is at 34B.
Last name. The allotment order issued by the government of Assam in favor of Dinanath Bora has been annexed along with the criminal petition as annexation number B. Stop. Issue notice to the respondents as learned additional public prosecutor has appeared for respondent number 1. No formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is no formal additional public prosecutor for respondent number 2. However, as regards respondent number 1 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 at
1, your lordship.
respondent number 2. It is having address of Kolkata as well as Sibsagar
Sibsagar.
at both the addresses mentioned in the
They are the respondent number 1.
One, lordship,
respondent number 1
lordship.
at both the addresses mentioned in the criminal petition. Stop. Let this matter be listed after 4 weeks. In the meanwhile, considering the fact that the petitioner is neither an employee nor an officer of the respondent number 2 company. Moreover, prima facie, it appears that the land in question was allotted to the husband of the petitioner by the government of Assam, the operation of impugn order dated 24/1/2024 shall be kept in abeyance until further order. Since this interim order has been passed ex parte, the respondent number 1 shall be at liberty to file an application for altering or vacating the same on their appearance. Fix this case after 4 weeks.
Deeply agreed. The company is respondent number 1.
I think state is respondent number 2, DP company is respondent number 2. That's available.
Deeply agreed.
My lord, I'm sorry to speak out of turn, my lord, but I just noticed that item number 33 to 36 was mentioned, but Mr. D.K. Mishra was leading in item number 35 and 36. We were not informed that the council in 33 and 34 would be taking time. There is an interim in our matters which needs to be continued, my lord.
Now, what is your prayer?
My lord, we also were going to seek for time today, but when the matter would have come up, because Mr. Mishra was leading in this matter, he's not well.
Item number 34 and you are in item number?
35 and 36, my lord.
Oh, it is a tag matter.
Yes, my lord. So we were
34.
not informed that they were going to take time in 33 and 34.
Okay, now what is your prayer?
But just the interim may be continued in 35 and 36.
Okay, in item number 33, 34 already mentioned, I say. 35 and
36, my lord.
35 and 36. Hard learned counts, hard Mr.
A Sandilya, my lord.
A
Sandilya. A Sandilya.
A
Sandilya.
Shandilya, learned counsel for the petitioner who prays for an adjournment on the ground that conducting senior counsel Mr. D.K. Mishra is unwell today.
Yes.
Considering the ground submissions made by learned counsel, the prayer is allowed. In 33, 35 or human being, I say. Let this matter be listed after 3 weeks. The interim order shall continue till next day.
Right.
May it please the Lordship. In this case, the petitioner was initially arrested, my lord, and thereafter, when charge sheet was filed under section 341, 354B of IPC, he was granted bail by the trial court, my lord. And thereafter, my lord, page 17 is the order, my lord, continuing.
Yes.
Page 17 is the order granting him bail, my lord, by the trial court. And during the COVID period, my lord, summons were issued to him. And it was not properly served upon him, and thereafter, my lord, NBW was issued to him. And now, my lord, we are aggrieved by the order dated 28/11/23,
Page?
Which is at page 23, my lord. Page 23, my lord.
Okay, now what is your?
Actually, what happened during the COVID time, the client instructed me that shifted to their maternal house, my lord. And that possibly could be the reason, my lord, why they have not been received.
You have not received the summons.
The summons, my lord. And now, my lord, I am already on bail, and the matter is fixed on 22/3/2024, my lord. I will appear, my lord, and I'll face the trial. It is that because of that period, my lord, some miscommunication has happened, my lord. So my limited prayer, my lord, Lordship, may kindly interfere with the order and allow me to remain
Yes.
on bail, my lord.
Mr. Das, anything?
Lordship.
Let him appear.
Lordship.
Heard
He'll appear.
heard Mr. M.A. Chaudhary, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, has been filed by the petitioner Mohammed Taizul Hussain alias Faizul and what is his name?
His actual name is Taijul Hussain, my lord. And Faizul is his nickname, my lord.
Faizul,
Yes, my lord, Faizul.
yes, impugning the order dated
Page 23. my lord.
28. Whereby non-bailable warrant of arrest as well as order for proclamation and attach proclaiming him as a absconder and attachment of his properties were issued by Learned Chief Judicial Magistrate Dima Hassan. Stop. Learned Counsel for the petitioner has submitted that. By which order you were granted bail?
My lord, it is a page 17, my lord. Page
Yes.
Annex 2.
That by order dated 18/12/2019, the petitioner was allowed to go on bail of rupees 20,000 by the Court of Learned Chief Judicial Magistrate Dima Hassan. However, thereafter, there was an outbreak of COVID-19, and during that period, summons were issued to the petitioner. Stop. It is submitted by Learned Counsel for the petitioner that due to outbreak of COVID-19, the petitioner had shifted to his
Maternal uncle's place, my lord.
maternal uncle's place, and therefore he had not received the summons issued by the court. And in the meanwhile, the trial court issued non-bailable warrant of arrest against him and also passed the order which has been impugned in this case. It is submitted by, when you came to know about the,
Very recently, my lord, my bailer informed me, my lord.
who?
Bailer, my lord.
Okay.
My-
It is submitted by Learned Counsel for the petitioner that very recently, the bailer of the present petitioner who took his bail initially in this case had informed him that regarding issuance of non-bailable warrant of arrest against him. Stop. It is submitted by Learned Counsel for the petitioner that petitioner has not willfully defaulted in appearing before the court, and he is ready to cooperate in his trial and appear before the Learned Trial Court and seeks some protection so that he may appear before the trial court on the next date fixed, that is on
22/3/2024, my lord.
22/3/2024.
3/2024. That is next.
2024. Stop. I have considered the submissions made by Learned Counsel for both the sides and have perused the materials on record. Considering the submissions made by Learned Counsel for the petitioner that the petitioner is willing to cooperate in the trial and he is seeking only an interim protection so that he may appear before the Learned Trial Court, comma, this criminal petition is disposed of with a direction that the petitioner shall appear before the Court of Learned Chief Judicial Magistrate Dima Hassan in PRC case number 122/2019, corresponding to GR case number 314/2019 on 22/3/2023. 24, and to facilitate his appearance before the Learned Trial Court on the said date, the operation of impugned order dated 28/11/2023, as well as the operation of non-bailable warrant of arrest issued against the above named petitioner shall be kept in abeyance till that date.
And
With-
he he may be allowed to remain on bail, my lord, as has been reflected in
No.
page 7, my lord.
No, the operation of non-bailable warrant of arrest will be kept in abeyance. You may pray before, on his appearance before the trial court, the petitioner may pray for any relief before that court to which he is legally entitled to. With this observation, this criminal petition is disposed of.
I'm deeply obliged.
Item 6.
May I please, Your Lordship? This bail application under section 438. My lord, here the informant and the present petitioner number, my lord, 2, my lord, they're the member of a self-help group, my lord. The self-help group name is Malibari Shatro Women Self-Help Group, my lord. Total, my lord, the 11 numbers of members in this self-help group, and they have taken a loan, my lord, from the government, 1,50,000, my lord. Total 11 members, and they have taken loan 1,50,000. And my lord, it was to pay the government, my lord, by installment basis, my lord. Per month, my lord, it was 8,900, and individually, my lord, it was 890 rupees, my lord. Thereafter, my lord, what happened? The informant says in the affair that the present petitioner number 2, she is one of the member and secretary of the self-help group, and one is the husband. Husband is not the member here. And well, husband and present petitioner, my lord, taken the money, and it was not paid, my lord, the installment. And several times the members, my lord, requested to hold the meeting. Though meeting was lastly held, but it was not settled. And the affair, my lord. This is that, my lord, the sum of the member, my lord, regularly not paying the, my lord, installment. Therefore, my lord, sometimes it is default. And my lord, already 18, my lord, 8 installment already has been paid, my lord. I think, my lord, this is a case of civil suit, my lord. While the loan is default, my lord, and they become defaulter, my lord, the authority will first issue the notice, my lord, and recovery the loan, my lord. But here, criminal, my lord, it is certain may not be here, my lord. I have stated in paragraph 7, my lord, the entire story. Some members irregular, and in fact, he
Installment
admitted.
number 2 also took loan.
Yes, ma'am. 2 is the secretary as well as member.
Okay.
Total 11 member.
How much loan you took?
Well, 1,50,000. And it was for 18 months, and per month installment was 8,900, and individually was 809 rupees. And some of the members, well, regularly it was not paid. Therefore,
No, this 1,50,000 loan was taken by all 11.
all 11, ma'am.
Not only you.
Yes, ma'am, all 11.
Okay.
And thereafter, my lord, it was divided, my lord, equally. And my lord, after divided equally, the total, my lord, EMI was 8,900 on behalf of the, my lord, the self-help group. And individually it was 809 rupees. In fact, my lord, the some installment is, my lord, failed, my lord. Because the present petition number 2 is the secretary, she is liable to pay, my lord. And the other member will deposit in her hand, and she will pay in behalf of the, well, on behalf of the self-help group, my lord. Regularly, sometimes they are not paying, my lord. One paid, another may not pay. These are going on. So, my lord, the whole case is civil national, my lord. Because my lord, the loan authority still now has not issued any notice, my lord. On apprehension, they have filed this case, my lord. In future, it may be problem. Therefore, the other member file this case, my lord. But already they will settle, my lord. The Honorable Court may consider this very much. Because the amount is not so high amount. my lord.
Apart from non-payment of loan, there was some altercation also.
Altercation part is, my lord,
Doubling amount is also there.
What?
In the, as per rules in this paragraph 2, Lordship. Page
Yes.
number 10.
Yes.
As per the rules of the group, president wanted to divide you and your Lordship. In the fourth line, by telling us we will make the amount double and make us understand that after making profit, the details of the loan attached. Moreover, Lordship, in the last, as per our group rule, after 1 month, we should, details of the money is also not given, Lordship.
whether the meeting is not held until the detailers need given, I think it is not a criminal liability. Because the authority of the loan sanction till now, my lord, not issued any defaulter notice to them, my lord. So I expect that it will be settled, my lord, because 11 person, 1,50,000 only, and all the.
No, is it a case where the others are paying and you have not deposited?
No, my lord. I have
Definitely.
stated that all are not fully in same time not paying. Suppose the due of the installment is first week. Somebody may not deposit after first
Yes.
week. So
What is to be done? What is your submission?
Lordship, otherwise, if we look at the preliminary Lordship, it seems like it's a civil. But Lordship, only the fact is that he is not giving any details and only that is there, Lordship. CD is necessary, Lordship.
he informant also not mentioned clearly in the FIR. I cannot understand
Otherwise-
clearly exactly what she is saying, madam. All of the lady, madam, I think, madam, the matter
Otherwise,
is
I
not
leave it to Lordship, Lordship.
relate to monetary transaction. What happened, madam? Suppose first week is the due of the EMI. One member gave and another is absent. One gave 15, another gave on 16 of the month, on 20. So the secretary is in no problem because secretary is the petition number 2. Cannot ballot pay the installment regularly.
Okay, how, Mr. In
Anuddin, madam.
Uddin, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Jamal Uddin Ahmed and Muhammad Jamila Khatun, who are apprehending their arrest in connection with Boko PS case number 620/2023 under section 420/406/294/506/34 of the Indian Penal Code. The gist of accusation in this case is that on 13/12/2023, some of the members of Malibari Satra Self-Help Group had lodged an FIR before the in charge of Mandira Police Outpost under Boko Police Station, Inter India, alleging that the 11 members, including the president and secretary of Malibari Satra Women Self-Help Group, have taken loan of rupees 1,50,000 from government, and which was to be returned back in 18 installments of rupees 8,900 per month. However, it is alleged that What is the allegation?
The allegation was that installment is when it failed to pay, my lord, the president and secretary. And their apprehension is they were going to be defaulter and criminal liability will come, hence the FIR. But my submission is that some members is defaulter and in time, my lord, they could not pay. Therefore, admitted fact, some installment is still now is due. But yet the authority is not declared the defaulter.
Where is in vernacular?
But that is page number 16.
It is alleged that the petitioners assured the members of the self-help group that they will make the profit. They will make double profit out of the loan amount taken and would also share the profit as well as repay the loan to the government. However, they have not given any details of payment of loan, repayment of loan to the government, to the other members. And when the members, that is the informants, question the petitioners regarding non-payment of loan, they were ill-treated and intimidated with slang language. Stop. What is your submission now? Learned counsel for the petitioner has submitted that some of the members, though the loan had to be repaid at an installment of rupees 8,900 per month, each member of the self-help group had to share rupees 809 per head. However, some of the members have defaulted in payment of their share of the repayment, their share of the loan repayment.
And 8 installment already paid, man.
It is also submitted that the self-help group, of which petitioner number 2 is
the secretary.
Is the secretary, has already paid 8 installments.
And within short time, well, they will fulfill the.
And
due-
within very short time, the remaining installments would be paid. Learned counsel for the petitioner has also submitted that this criminal case has been filed against the petitioner only to harass them, whereas the dispute in this case is predominantly civil in nature. Learned counsel for the petitioner has also submitted that they are ready to cooperate in the investigation. However, as the police is frequently visiting their residence, they are apprehensive of getting arrest in connection with this case. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application, hence call for the case diary. In the meanwhile, as apparently it appears that the dispute between the parties from the materials available on record at present appears to be predominantly civil in nature. Therefore, both the petitioners are hereby directed to appear before the investigating officer of BOCO PS case number 620/2023 within a period of CD would be required.
I think may not be
Because
required.
threatening
But
party is
session
also,
judge has perused the CD.
No, my lord, I think when it's
threatening
case,
party
my
is
lord,
also there, Mercy.
ultimately the
Okay.
alternative they can take
Okay.
next time also.
Within a period of 10 days from the date of this order. Stop. If both the petitioner do so within the stipulated period of time, comma, in the event of their arrest in connection with BOCO PS case number 620/2023, comma, the above named petitioners shall be allowed to go on interim bail of rupees 30,000 with 30,000 each with one surety of like amount to the satisfaction of the arresting authority, subject to following conditions. Condition number 1 and 2. Let this case be listed after piece of
10th April,
3.
Lordship, date may be fixed, Lordship,
Date of
10 April.
23rd April.
Lordship.
My lord, sorry to interrupt, Lordship. I beg to item number 42, Lordship. Yesterday I made a mention to that regard as because Lordship, appellant is admitted in the GMCH. That is why Lordship allowed to list the matter, Lordship. But Lordship, I made a mention along with that, Lordship, to take up this matter at 2. But it is not shown in the cause list, Lordship. That's the problem, Lordship. If possible, at 2, Lordship.
No, it
Oh,
is
for
not in
orders.
the- Not in the cause list.
It is in the cause list, but 2 is not shown, Lordship. Lordship will take up at 2 or not. Lordship, kindly my prayer to take up the matter at 2 if possible, Lordship. For orders matter, Lordship. For bail hearing, Lordship.
If I allow such kind of mentioning in between,
No, Lordship, I made a mention because bail hearing not yet started, that is, Lordship.
okay.
I'm like,
Item 14.
Yes, Mr. Bishas.
No, I was in item 7, so I thought.
Bail hearing, bail hearing. You will take
14. How much? 14, 1/4. Lordship, my senior is on late.
let us complete bail hearing. Thereafter, we'll take admissions.
Okay, Lordship.
No, you have, your item is item number?
14, Lordship.
Yes.
Lordship, my senior is on late. Senior another group.
Okay, after something, let him come.
Lordship. Okay.
Item 15. Item number 15.
Listen working.
Item number 16 and 17.
Mention করেছে।
16 is charge sheeted, Lordship.
Okay.
16 is charge sheeted. 16 and 17 both.
পিছত মাতিম।
Item number 19.
CD not available.
CD not available. Open মানে none appears for the petitioner on call. Learned additional public prosecutor submits that it needs some more time for production of the case diary, as same is not available today. The prayer is allowed. Let this case be listed again after a week.
Lordship, apologize, Lordship. In 19, it is also charge sheeted, Lordship.
Charge sheet has been Then an additional public prosecutor has submitted that in this case, though case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
293/2023 dated 30/11/2023.
It appears from record that the order dated 18/10/2023, the petitioners were allowed to go on interim anticipatory bail on certain conditions. As charge sheet has been laid, the interim bail granted to the petitioners by order dated 18/10/2023 is hereby made absolute with condition number 1, with condition number 2, 3, 4, and 6 attached to the said order remaining intact. With above observation, this bail application is disposed of.
Item number 15.
To Markano Singh.
May I please, Your Lordship?
CD is not available, Lordship.
Long pending. Yeah,
Certificate only. Last.
last 26/9/23 is the observation visit.
Okay.
There's observation, my God. 26/9/23.
You are on interim bail.
Yes, ma'am.
You have appeared before the IO,
Yes, ma'am.
CD not available.
but for so many days.
Lordship, I understood, Lordship.
We are disposing of this case.
Last chance, Lordship. One last chance may be given.
Heard Mr. A.R. Sikdar,
S.I. Talukdar.
S.A. Talukdar,
S.I.
S.I. Talukdar, learned counsel for the petitioner. Also heard Mr. K.K. Das,
Yes.
learned additional public prosecutor, who submits that the case diary has not been sent to him by the investigating officer and prays for one last chance to produce the case diary.
2nd April, Lordship.
Considering the submissions made by learned additional public prosecutor, the prayer is allowed. Let this case be listed again for case diary on 2nd April 2024. The interim order shall continue till next day.
Hello.
For admission item number 7.
Lordship, in this case, Lordship, we are
My lord will see the last order,
supposed to deposit rupees.
only the
8
last
lakh,
order,
Lordship.
the last order.
But I am paying for again the last 1 month chance, Lordship, for adjournment, Lordship. Because
What was the interim order?
My lord will kindly see the
20
order passed by
24
this court 4 years back. That is on 24th of March 2020. 4 years back, what order this court has passed, my lord will kindly see.
that order was vacated, Lordship.
Vacating part is different, my lord, but there is a direction to pay 8 lakh rupees.
That order was vacated.
Yes, Lordship.
That order was vacated. They made an
What is the
undertaking.
case?
My lord, the NI Act case, they made an undertaking that we will pay 8 lakhs, give us interim protection. 4 years back, the court gave them interim protection and directed to pay 8 lakh rupees.
The impugned judgment was stayed.
State. Into judgment was state with a condition that you pay 8 lakh rupees. It has been 4 years, not even single penny paid. On the last occasion, that interim, the stay of the proceeding was vacated. The payment order is not vacated. Stay of the interim is vacated because they have not complied with the order.
But stay is vacated.
Yes, sir.
Stay of the that is vacated, but the direction to pay 8 lakh is not vacated.
No, if they fail to pay, the judgment will be enforced.
Yes,
Absolutely.
yes,
ma'am.
Lordship.
Now
Yes,
again
yes,
today they
yes,
are renewing
yes,
their
yes.
prayer.
Lordship, I am praying for some time, Lordship. Lordship may peruse the medical report, Lordship. He, from 2022, he is admitted in hospital, Lordship, and amputation was also done, Lordship.
No, this is an appeal against NI Act
Yes.
138 under section 138 conviction was made.
Admission,
You
admission.
were convicted.
Yes, Lordship. Admission will be subject to payment of the 8 lakhs rupees, Lordship.
The appeal has not yet been
Yes,
admitted.
not admitted.
Not yet been
Not
admitted.
yet.
4 years because they did not pay the money. It is subject to payment of 25%.
Oh,
Yes, Lord. So, Lordship, I am paying for last
then
chance,
there
Lordship.
has to be a limit. It cannot go on for.
Yes, Lordship.
4 years
Lordship,
already.
I am also handicapped. Lordship may grant us last 4 weeks time, because I have seen today morning also they have sent, Lordship. 4 weeks last time, Lordship.
Let him
Because-
let him take 2 weeks.
Here,
Now I can understand my brother's problem, my lord. After all, an advocate can only inform his client, my lord. He
Lordship,
cannot.
I have just now because certified copy of the order is also in my file, Lordship. From 2022, he was admitted in hospital of Delhi, Lordship, and amputation was he was underwent with amputation.
No, but what is the assurance that after 4 weeks you will pay?
Lordship, if
Because
he-
you are still admitted.
Yes, sir.
After 4 weeks, things will remain same.
Lordship, I will leave it on Lordship after 4 weeks. Lordship may pass any order.
We can
Because-
pass it today also.
Lordship,
the
only
same order.
because they instructed me to pray for last 4 weeks time.
Because for last 4 years,
Yes,
this case is not yet.
I am also handicapped, Lordship. Therefore,
Yes, Mr. Vishwas.
My lord, my prayer is
He is
what
also my brother,
what has been recorded by this court. That's my prayer, my lord. At least let them pay the 8 lakh rupees or let the appeal be dismissed at the threshold, my lord. Law will take its own course, my lord. Because 4 years is
What interim order was cancelled?
the interim order that the
24th.
stay of the impugned judgment was vacated
By last order.
by last order.
Okay. Then he has to surrender
He has to surrender. Now he is in,
or
he is now in a hospital, Lordship.
okay. Heard Mr. K. Kolita, learned counsel for the petitioner. Also heard Mr. M. Bishwas, learned counsel for the respondent. It appears from order dated 21/6/2023 that by the said order, the interim order passed on 24/3/2022, by which the impugned judgment was stayed.
Operation of the sentence.
Operation of impugned judgment was stayed, has been vacated. So, however, for admitting the present appeal, the condition as provided under section 148. 148 or 143?
140, my lord, 143 meeting. I'll just check it. 143. 143 power to 143A power to direct. No, it's 148, my lord. 148.
Under 148 NI Act, the petitioner had to pay a sum of rupees 8 lakhs, and for which on earlier occasion time was prayed for by the petitioner on the ground of ailment of the present petitioner, the ailment of the petitioner, on the ground that the petitioner was ailing. Stop. Today also, learned counsel for the petitioner has submitted that the petitioner is presently admitted in
Lordship, I have given Ashlock Hospital, New Delhi. New Delhi.
Ashlock Hospital, New Delhi, as he is suffering from certain ailments and has again prayed for allowing the, again prayed for 1 month more time so that petitioner may pay the amount of rupees 8 lakhs as directed by this court. Learned counsel for the sole respondent concedes to the said prayer.
Concede may not be the, my lord. I am opposing, my lord.
You're
Concede-
opposing, then I will.
I am opposing, my lord.
You are
I'm
not
conceding.
opposing.
I am opposing, my lord. I am not conceding because 4 years has elapsed, my lord. Your lordship discretion.
Though learned counsel for the sole respondent have opposed the prayer. However, considering the health condition of the petitioner, one last chance is granted to the petitioner for payment of rupees 8 lakhs. Stop. Let this case be listed accordingly on
One fixed date, because my lord, the experience has shown that it's after 1 year, this matter is getting
after
lifted.
in
At a
the,
date
in the
date.
month, first week of May,
They get a date date.
3rd May.
My lord, with some writer that positively they will pay before.
No, if they don't pay, we will not admit.
But some observation, my lord, because
If they don't pay, the consequence will follow. Because such observations were made. If the petitioner if the petitioner fails to pay the said amount, the consequences would follow.
I'm replying.
Stop.
I don't mind.
Your lordship, the matter may be adjourned for the day, and 2 weeks' time may be granted, your lordship. I'll file an affidavit in opposition.
Actually, my lord, matter is pending since 2022 and it part.
What is the matter?
My lord, the matter pertains to custody of children between divorced husband and wife, my lord.
Okay.
So one child is with mother and two, my lord, the children are with. My lord.
Which order you are impugning?
My lord, page 18, my lord. Page 18 and another one.
The case is still pending. The
No, my lord, the order has been passed by the district magistrate, my lord.
this order has been passed by district magistrate.
My lord, impinged order page 19, my lord, another 2. Another 2. Passed by the additional district magistrate, Kasar Silchar, my lord. Yeah.
Whether the records have arrived. That's it.
I have not checked.
Records would be required.
My lord. So a short date may kindly be given, my lord, and they also, my lord, seek some time, my lord. To find I feel it.
No, but records would be required. Or without record, we can hear.
Yes, my lord. I think, my lord, without records, the matter can be
How?
hard by lord. My lord, on the basis of the available documents, my lord.
Because this is a revision, criminal revision.
Criminal division, that is right.
Here, he will not be allowed to file affidavit and counter affidavits.
Yes.
They filed, you may file objection in form of affidavit.
Objection.
Yes, my lord. A short date may kindly be given, my lord. Our matter is pending since 2022. my lord. Last topic.
Heard Mr. A.R. Talukdar, learned counsel for the petitioners. Also heard Mr.
A.N. Iqbal,
A.N. Iqbal, learned
correspondent number 2.
counsel for respondent number 2. Who is appearing for respondent number 1? State.
For state PP addition.
Heard Miss B. Bhuya, learned additional public prosecutor for the state respondent. It appears Mr. Learned counsel for respondent number 2 has prayed for allowing how much time?
2 weeks, your lordship.
2 weeks time for filing his objection in the form of affidavit. It appears from record that the case record of case number 723M/2022, in which the impugn order has been passed, has not yet been called for from the Court of Additional District Magistrate Kachar. This court is of considered opinion that the said case would be required for consideration of the present criminal revision petition. Hence, registry to issue requisition for calling for the case record of case number 723M/2022. This case pertains only to custody.
My lord, custody of the children.
So after this order, nothing is going on in that. Whether any proceeding is
No,
going
my
on.
lord. No, my lord.
Okay, so there is no harm if we call the case.
Yes, my lord. You're not to
Last
make all the records.
Release this matter after 2 weeks.
A date may kind of be fixed, my lord. Otherwise the matter will be
After-
pending.
It will be with the 23rd of April.
What a long way.
Oblige করো।
NCR what has. Oblige your lordship.
My pleasure, Lordship. Lordship, application under section 482 for passing the FIR. Lordship, today is the fourth occasion where we have not got the CD. I think it's sufficient time has been given already.
You are for,
Respondent number 2.
what was the case? Allegation under 384.
Lordship. 384, 341, and 67 of ITR.
Case diary,
Lordship, the records in my file says scan copy of CD from.
scan copy,
I'm sorry, Nikki, because
I say scan copy.
whether I just come, I have not verified the records, my lord. I'm sorry, my lord, nearby only. May I pray for a short of accommodation, my lord?
Lordship, only two lines, please, go for page number 23. There is bail order, heavy order. From the third line, Lordship. Record reveals that in the instant case, interim pre-arrest bail was granted to the petitioner Konkon Nath on 19/10/2022. And the police was directed to send the CD on the next date fixed, that is 28/10/22. Record reveals that on last 6th date, the investigation agency has failed to produce the CD before this court for consideration of the prayer for pre-arrest bail of the petitioner. In the second paragraph, the court is of the opinion that the investigation agency has failed to discharge their duty to assist the court by producing the available materials of investigation. Same thing is going on here also.
Lordship,
It will not.
so for default committed by whatever the state agency, he has got the benefit. He has taken advantage out of it. May I be given a short date? I'll try to obtain the CD.
Mr. What is your name? S. Chaudhary.
Yes, sir.
Heard Mr. S. Chaudhary, learned counsel for the petitioner. Also heard Ms. B. Bhuya, learned additional public prosecutor, as well as Mr.
D. Doctor.
D. Dutta, learned counsel for respondent number 2. Learned additional public prosecutor has prayed for some more time. No, though learned counsel for the petitioner has submitted that this is the fourth occasion when the case is fixed for receipt of case diary. However, same has not yet been produced. Stop. However, learned additional public prosecutor has prayed for some accommodation, assuring this court that case diary would be produced on the next date fixed. Considering the submissions made by learned additional public prosecutor.
On 27, my lord,
Prayer is
27/3.
Will you be able,
Chances are nearby only. I'll try, my.
let this matter be listed again on 27/3 for case diary.
That's
all. Nice.
May I please, your lordship? Lordship, there is a 482 petition for quashing of FIR. Lordship, the FIR was lodged in Chanmari in the year 2014 itself. It was lodged under section 381 of IPC. My lord will find the FIR in page number 17.
Just a minute.
Yes, ma'am.
Yes.
My lord, in case number
Whether case diary has arrived. Whether case diary was called for.
Records with me, my lord. No copy of the petition is not available. No? Lordship, no.
My lord, this case has been listed for the fourth time today, my lord.
But case diary was,
It was called in the month of November itself, my lord.
case diary was called for.
In the month of November itself, my lord, on 2011-2023.
Would you please? Yes, Chanmari, please. To case number
430.
Case diary has,
No, Lordship, we have not received. I pray for short accommodation.
has not been called for.
My lord,
On 2011,
Oh,
the additional PP sought for some time for seeking instructions
As to, my lord.
regarding the case, whether the charge sheet has been laid or not.
Okay.
My lord, sir, it's going to be 10 years now that the charge sheet has not been filed. 2014 case, my lord. As a result, the petitioner has lost multiple employment opportunities because in the background verification, the bail orders come up and then he's unable to answer as to what happened against the allegations that are.
But unless we peruse the case diary, we may not be in a position.
I
to-
understand. But my lord may then.
Second one.
Call the case, you produce the case diary.
For Chanmari to could request, but so could not. No, what it can be there. This is a registered.
Miss
As thus.
S. Das, learned counsel for the petitioner. Also Miss D. Bhuyan, learned additional public prosecutor. It appears that in this case, the petitioner has approached this court under section 482 of the Code of Criminal Procedure, praying for quashing of the Chanmari. We have prayed for quashing of the entire case.
Here,
Or the-
FIR, my lord. 433 of 2014 minutes. Chanmari PS.
No, you have prayed for quashing of Chanmari PS case, not the FIR.
Yes, my lord. That is the FIR. PS case number 433 of 2014.
That is not the FIR, that is the
That is
case.
the PS case, FIR
PS.
number.
That is the case number. After filing of an FIR, a PS case is
My lord,
registered.
page number 15, it's.
FIR is to be mentioned by date.
Date
FIR dated so and so.
12/8/2014.
Because on reading it gives a confusion whether
Yes.
are you praying
So
for.
next page, request as a Chanmari.
Page number 15, my lord, that is the original.
Oh, Chanmari as well. So, this is the key and here no have another section key.
381.
You read your prayer D. Prayer D. There are A, B, C prayer. B is your main prayer.
Yes, my lord. And that is Chanmari FIR number is 433. That came as.
What is your prayer?
PS case number.
You are praying for quashing of the case number.
Yes.
Praying for quashing of Chanmari PS case number 433/2014 on the ground that though the FIR in the said case was filed on 12/8/2014, however, till date, no charge sheet has been laid in this case. Stop. It appears from the record that though on 2011-2023, learned additional public prosecutor sought some time for seeking necessary instructions. However, it appears that the instructions are not yet available with the learned additional public prosecutor. It also appears that case diary has not yet been produced before this court. For consideration of the instant criminal petition, the perusal of the case diary of Chanmari PS case number 433, 2014 would be necessary. Hence, call for the same. Learned additional public prosecutor shall ensure the production of the case diary on the next date. When
27.
27?
My lord, can it be in the first week of April?
Yes,
Any date on the first week?
first week of April.
Second April.
Let this case be listed again on 2nd of April.
Much obliged.
Please, your lordships. Lordship application under section 482 for quashing the search sheet. It was first filed for quashing the FIR, but subsequently search sheeted case was search sheeted. LCR is received.
Yes.
Lordship, it's a joint petition by the informant and the petitioner, accused.
Informant also, victim.
Victim also, because it is a complete private nature, Lordship. They were in love since long time.
You have brought some judgments where
Lordship, yes. The one is there.
where on joint prayer by victim as well as accused,
Yes, Lordship.
the charge sheet may be quashed.
Page number 56, Lordship.
We have annexed it. Page 56.
56. Annexure 6. It's a Kapil Gupta versus State of and City of Delhi and another. And page number 62.
Kapil Gupta, what is the relevant provision, relevant paragraph?
62, para number 16. In the last page number 16. Though the search sheet have been filed, the charges are yet to be framed, and as such, the trial has not yet commenced. It is further to be noted that since the respondent number 2 herself is not supporting the prosecution case, even if the criminal trial is permitted to go ahead, it will end in nothing else than an acquittal. If the request of the parties is denied, it will be amounting to only adding one more criminal case to the already overburdened criminal courts. That means it is.
Whether this has been reported, Kapil Gupta has been reported.
Lordship.
Anywhere. Do you have the citation?
Yes, Lordship.
Yes. Tell me the citation.
It means in the main petition.
No. Citation of the Kapil Gupta's case. Kapil Gupta's case has been reported in some law reports.
Lordship.
You can find it out.
It's SLP criminal number 5806.
That is the registration number. I am asking you, is this case has been reported somewhere or not? In some
Law journal.
law report.
That is not clear, Lordship. Only from the
Perhaps it has been reported.
reported.
You try
only-
to find out. You have given the original print,
Yes, Lordship.
but try to find out.
Lordship.
Then what is your next submission? We can hear this for disposal.
He wants, I think he wants the
Second half.
second of Nalagi Belay go.
Thank you.
No, do it in second half.
No,
There
he
is
said he wants to see go for the citation, whether it's reported somewhere. I don't think at the face of it, it can be compoundable, my lord.
No, but because of Kapil Gupta,
Okay.
it is a Supreme Court judgment. almost same allegations.
No.
The victim and you were in love affair.
Yes, Lordship. In the bail petition also, here also already we submitted. And deed of compromise has been submitted in this. Page number 17, Lordship. And
No,
exact three.
apart from Kapil Gupta, what other case? Gyan Singh is also there.
Yes, page number 24 and page number 26. There are 3 citations. Kapil.
Gyan Singh,
Gyan Singh
relevant
also there.
paragraph.
And Madan Mohan Abbott also there. All are from Supreme Court. There are 3 judgments.
What is the relevant paragraph? Are you ready for hearing?
Yes, Lordship.
You,
We have got the records here, my lord.
Because, Lordship, if you go through the LCR, you will find.
no, I am ready to hear it. But subject,
Lordship, but I have not gone through.
okay, you go through it. When can we do it? Tomorrow, day after?
27 to go.
27.
27, my lord.
Okay.
Lordship.
Now it's Mr. This is item number.
13, no?
13.
Out Mr. S. Chaudhary, learned counsel for the petitioner, also out Ms. B. Bhoya, learned additional public prosecutor, who prays for some accommodation as she has to go through the record of the case for arguing the case. Considering the submission, the prayer is allowed. Let this matter be listed
27
on 27/3/2024.
March.
Value plate.
Please, your lordship. 439, 439 application, lordship.
We need
In
to file
this-
our objection, lordship. I have done
Lordship,
for
it's-
record.
Earlier, lordship, dispose of the co-accused bail petition, lordship. In this case. In that case, lordship,
You have not filed any objection.
Yes,
since
lordship.
long time it was pending, lordship, because this benches was not available, lordship. But they have not filed objection right now. They are going, they made the
This
submission.
is partnered with this bench.
Because lordship, nowadays the Supreme Court pass a order that if lordship pass any order, that should go to that bench, lordship. Because of that reason, lordship, first lordship passed the order in.
Order in a police station case.
No, it's a NCB case. All cases, lordship.
No, if a court passes order in a particular PS case.
Yes, lordship.
All bail application in that PS
Yes.
case would, in respect of that FIR,
Yes.
will come to the said court.
Recently passed a judgment. One affair, one judge, lordship.
Yes, one FIR, one
One
court.
judge, one court.
So in this
In- in-
FIR,
in
I have,
this- In this case, lordship passed first 10/1/2024 regarding Sadiq Hussain Borbia.
in respect of other co-accused,
First petition, co-accused.
co-accused.
First
You-
petition, lordship passed the order. Subsequent,
You are for some other co-accused now.
yeah, I was appeared on that, lordship. That time, this order was not passed by the apex court. Subsequently, what happened, lordship? Subsequently, what happened, lordship? Other accused placed the order of this that honorable
But
court.
today is the second day only.
Yes, lordship.
In this case, today is the second day.
Third day, second day.
Second day.
Second day,
So they may file a written objection.
second day. Lordship, second day.
It has come up only once.
Lordship.
Let them file written objection.
Can it be on Friday, lordship, bail hearing? Lordship?
Subject to-
We allow us 10 days time, lordship.
How it is possible there inside co-accused already granted bail similar for Ting lordship? Because lordship, till today, no, though lordship passed the order first 10/1/2024.
No, but
till-
you came on February 20 only.
Yes, lordship, because 10/1/2024 lordship passed the order. Till today, no witnesses adduced by them, Lord.
Lordship, that is why we need
On
to file
Friday,
our
let
objection.
we fix on
We need
Friday,
to
Lord.
file our objection.
Because this bench is not always available because Lordship is taking up the other matters. That is the thing. It will come before your Lordship only. Because the other orders.
Oh, I am available for next 15
Lordship,
days.
holidays are in between, Lordship, that is why we.
On Friday, there is no holiday, Lordship. Next week.
Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Miss M. What's your name? M.
Deka.
M. Deka, learned counsel for the NCB, who prays for some time for filing written objection against the prayer for bail made by the petitioner. Considering the submissions made by learned counsel for NCB, the prayer is allowed. Let this case be listed again on
27, Lordship.
let it be on 2nd April. In between, before that, they will file objection with a
Okay,
copy
Lordship.
to the
2nd of April.
2nd April. Let this case be listed again on 2nd of April. The
28.
response, NCB shall file the objection at least
On
two-
27 or
at
28.
At least 2 days before the said date,
Okay,
with a copy of same.
Madam,
to
they may
the-
file the objection on 27 or 28 so that it may come on to the 2nd of April. Huh? Right, because those days are courts are open, Lordship. In the next week.
Yes, you file it by 28.
Lordship, we will file our objection in between, Lordship.
Yeah, 28.
Okay, Lordship.
On 28.
With a copy to the
Okay, Lordship.
petitioner. List accordingly.
Obliged.
Lordship.
Yes, charge sheet submitted.
Both the cases.
For both cases.
But
In the Lordship, the PS case is the same. However, it has been stated that has been charge sheeted fight Emran PS case, Lordship. Both the PS case is the same.
You were granted interim bail.
Yes, Lord.
You appeared before the IO.
Yes, Lord.
Heard Mr. What is your name?
Ghosh.
M. Ghosh.
U Ghosh.
U. Ghosh, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
16/23 dated 30/9/2023.
So, learned counsel for the petitioner has submitted that by order dated 11/9/2023, the petitioner Muhammad Khairul Islam was allowed to go on interim pre-arrest bail by this court with certain conditions. And in compliance to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Stop. In view of submissions of learned counsel for the petitioner, comma, as the petitioner has cooperated in the investigation, comma, the interim anticipatory bail granted to the above named petitioner by order dated 11/9/2023 is hereby made absolute.
Deeply obliged.
And in next is 17 is same.
PS case is the same, Lordship.
PS case is same.
Lordship, 17/23, Lordship. Emran.
Everything will be same except the name of the petitioner Runumani Begum.
Yes, Lord.
Name of the petitioner change kore dibo, baki eke thakib. This is
Deeply
also
obliged.
disposal.
Item number 41 from supplementary.
Satyaman.
Already argument concluded in this case, Lordship. I was directed to produce the CD regarding a relevant statement which I made before this honorable court regarding. Lordship, I
Now, whether the investigation is going on,
no, Lordship. Completed charge sheet has been filed, Lordship. Trial is about to begin, Lordship. The copy has been furnished to them. Hearing on the point of charge will be.
Today is the date fixed for
Hearing
on charge,
charge.
but
in which court it is pending?
Special court.
CBI two.
Special court to additional court number two, na?
Two.
The case diary was required as to whether what materials are there in the case diary against
Yes, Lordship. I have made a
Mr.
statement-
Ashok.
Yes. Regarding taking of randomly they are taking money, Lordship. It will reveal by the statement of one co-accused. I have made before this honorable court that one of the co-accused has stated regarding this accused.
Can we retain this case diary?
Yes.
Because we are going to reserve this judgment.
Lordship. Is there at the point of hearing of the charge, Lordship?
It will be
statement of
required.
it will be required.
When the date of hearing is
Today is the date fixed for hearing.
for consideration of charges. So we'll keep the relevant. I'll go through it, keep the relevant photocopies and return back the case.
Already photocopies I have already submitted, Lordship. Regarding only the point regarding the statement of the co-accused. That is required. Lordship can have a look also and take a copy of the photocopy of that statement also. My whole case diary will not be required, I think, Lordship. Because all the relevant I have submitted. Lordship.
At this stage, whether the statement of co-accused can be taken note of by this honorable court. When the charge sheet is submitted, at the stage of the investigation, when the bail is required to be considered in respect of the bail, then the statement of the co-accused is relevant.
Okay, apart from statement of co-accused, what else, other materials?
Yes, my lord.
With regard to other material, I have already submitted before your Lordship regarding the intercepted call.
Now, for what purpose we have to go through the case diary?
Because I have made a statement, I have made a submission before
Just a
the
minute.
honorable court that one of the co-accused has stated against this accused person that he has received some money. So for that, your Lordship would like to verify whether that
50,000.
50,000 and Lordship, the accused himself has stated regarding the receipt of the 50,000. The statement of the accused were also recorded. From his statement also, Lordship, will reveal
That is for purchase of some
DM plan.
DM plan.
DM plan.
And that is not relied on by them, with the charge sheet.
No, we are, even the materials are there also. Though we have not stated in our charge, but materials are there at the point of framing charge. This shows all these things, Lordship.
No, my lord.
It is not necessary that you'll have to state it before the charge sheet.
Here,
I'll have to state before the charge sheet and I cannot. Charge can be altered at any stage, Lordship. Frame the charge if the materials are available on record, Lordship.
okay, Mr. Haloi,
Lordship.
when was the last date?
Last date.
Putun, এই কেসৰ last date কেতিয়া আছিলে? কজলিছৰ চালে কোন? Last. Costless a blue colored হৈ থাকে, click কৰিলে. February.
29th.
Yes. Which pages?
Lordship, page number 62, Lordship,
You have given in your compilation also.
no, Lordship, this part was not available. Lordship. That is why, Lordship.
Whose statement? You can,
Statement of Alok Kumar himself here during his interrogation has stated.
what he has stated?
May I read, Lordship?
Yes. Because this copy of this has been furnished to the other side also.
No, statement of the accused we cannot furnish, Lordship. The part of the CD, Lordship.
161 statement you have furnished.
Yes,
You-
with regard to the witnesses, we have already supplied to them under 207, Lordship.
So this statement has not been.
Not furnished.
Okay. But you are relying on this.
Yes,
My lord.
and because I'm relying because this honorable court has directed me.
No, but 173 says the documents on which you are relying
Yes,
has to be furnished to them.
Lordship. In the trial, Lordship,
Yes.
In the
So
trial.
that stage is 207 only.
207.
During,
Yes.
at the stage of 207 CRPC, you have
Yes.
to furnish the documents.
Yes, now we are in 482, Lordship. Here we are in 482.
No, yes, but 207 is in the trial.
Yes,
So trial is proceeding because there is
Yes.
no stay in the trial.
yes. Trial is
So
proceeding.
at that stage, have you furnished the document?
The relied upon document we have furnished, all the relied upon.
But this document has,
This document we have not furnished.
okay. That is statement of the accused.
Statement of the accused and co-accused,
Statement of first is Alok Kumar.
Alok Kumar.
What he says,
Shall I read
this
the
statement is under 161,
one statement? It was not written anything, Lordship. It was
but
written
it has to be under 161.
161, yes. Statement of Alok Kumar, son of so and so, so and so. It was not written under what section it was recorded. Shall I read the whole statement or the relevant? portion?
Relevant only.
Only relevant. Further statement, in the further statement, Lordship, they have stated, on being asked, I further stated,
You flag it also. So
yes,
that
Lordship. I'll flag it, Lordship. On being asked, I further stated that on February 2022, I had not received any amount from Pankaj Saran of MS GR Infrastructure Private Limited of Guwahati. On being asked, I have stated that in the month of April, May, we received rupees 50,000 from Pankaj. Pankaj Saran is the one of the accused from GR Infrastructure. 50,000 of GR Infrastructure Private Limited. On being asked, I said that I knew Pankaj Charan of GR Infrastructure since 2019, as he was performing duty of project manager of MS GR Infrastructure. Further, I said that whenever I visited money.
No. Suppose this is a statement of the accused himself
Lordship.
and he is admitting,
Yes,
then this would be confessional statement.
but he was, no. Before the police, it cannot be confessional,
Therefore, it will not be admissible.
admissible.
So it has got no value at all.
Yes,
Then how you can rely on that?
no, I'm not relying, Lordship. I have stated on the last, during my submission, Lordship, I have stated that the accused had also admitted and one of the co-accused had also,
But this accused has admitted
yes,
is of no relevance because that cannot be relied upon.
exactly, Lordship.
So that part goes.
Lordship,
Now remains is the
co-accused.
co-accused statement.
Lordship.
Okay. But I am recording your submission that Alok Kumar also said that he received 50,000 from
Pankaj Charan.
Pankaj
Charan, PNK Pankaj, CHERAN of MS GR Infrastructure, Infra Project Private Limited, Guwahati.
Yes.
On being asked, I further state that I also know Sunil Agarwal, Vice President of GR Infrastructure since 2023. I met him first time at NHI head office, Delhi, when he was come from attending official something at head outer Delhi. After that, Sri Sunil Agarwal was with my contact. So this is here, only the relevant portion. And then lordship, the statement of Pankaj Charan lordship. Statement of Pankaj Charan was very long lordship. I'll rely on the relevant portion. I'll read out only the relevant portion. I did not pay any money to Sunil Verma. I was flying to head office. I was paying to head office rupees 6 lakhs to Sunil Verma on 12/6/2022. Before this, I was handwriting is very poor lordship. By
Because
CBI,
it
I
is
was
C-
asked by CBI. Now on specifically asked about the bribe amount transferred, I state that on completion of project work successfully, the management decided to give some contribution to NHI employees at Shillong, RO office Guwahati, and Aegis officials in the form of cash. In the month of May 2022, Sri Sunil Agarwal directed me to submit a list of employees to whom money consideration to be given. Accordingly, I prepared a list, and accordingly I sent a list. The said list was corrected by the management twice or thrice, and finally decided to give amount to the following officials. Number one, RO accountant 4 lakhs, RE Jitendra Prasad 8 lakhs, RP Singh Aegis 1.10 lakhs, Manoj RO NHI 4 lakhs, NHI 50,000, someone 2 lakhs, again PD Sunil Verma 6 lakhs. Thereafter, as mentioned in the earlier paragraph, the amount was on specifically asked when I come to Guwahati, I have given an amount of rupees 5 lakhs and received rupees 17 lakhs from Kamle. Now on specify and about the transfer with Alok Das. It was written as Alok Das, but I have verified there is no person in the name of Alok Das. It's Alok Kumar. It was written as Alok with Alok Das. I state that as instructed by the management in February 2022, I have handed over rupees 4 lakhs to Alok Das at the office. So there is no person as Alok Das. If you lordship go through the entire case diary, only this person Alok Das inadvertently it was written. It was Alok Kumar. So 4 lakhs rupees that co-accused is given to him. Like that.
These two statements.
These two statements and telephonic conversations are there, lordship. So those telephonic conversations.
Any statement, statement আছে এরকম photocopy করি সিটি কোন মশাই সিটি কোন ঘরে বাজিয়ে করে
Your lordship, I'll hand over this one. Here I have written in 3, volume 1, that means this one, page number 96 and 87. Your lordship, I have flag mark also, page number 96. Statement of Alok Kumar.
You take back this CD today itself
Lordship.
in the evening.
Lordship.
I'll get the relevant portion Xerox.
Lordship. Other, yes. And 69 and 87. 87, lordship. Handwriting is very poor, lordship. Lordship, I will flag mark by green page. Lordship. Nowhere it was given in green flag, so your lordship will recognize. the green page, and along with that, one pink flag mark also there. Here you also will find the page number also. This is the volume 1. Page 461. So this is the telephonic conversation.
Which you have already given.
I have already, perhaps this was not there, Lordship. This is the telephonic conversation between Pankaj Charan and Sunil Agarwal and 3 persons. There's a conference, Lordship. Pankaj Charan has called Sunil Kumar and made Alok Kumar to talk to him for release of bank guarantee of rupees amount in April 2022, for which Alok Kumar assured to Sunil Agarwal that he will look after this issue. Nothing to worry. Also, during interaction, Alok Kumar, he had admitted that he had received rupees 4 lakhs from Pankaj Charan. This is very important also. Telephonic, we have relied upon, we have given to them also. This one.
No, but during telephonic
Conversation.
conversation,
Yes.
he has not said that you give me in lieu of this, I am releasing it.
Direct, Lordship, there are Supreme Court judgment also. Smart public officer will never, Lordship, demand any money directly, Lordship. Indirectly, they will demand, and from the Lordship circumstances, from these circumstances, it reveals, Lordship, it's nothing and none other than the demanded money for the release of the bank guarantee, Lordship. What duty he has to receive money from a company of?
But is there any bar that he cannot talk to?
He can talk, but he cannot receive money from him.
But regarding that conversation, there is no indication that any money would be paid.
Money has been received.
Indirectly also, there is no.
No, there is. I will read, Lordship. Alok Kumar, अच्छा ये मेरे को सीरियस मैटर का 4 लाख रुपीस का कम हुआ ना. 4 lakhs rupees he has admitted.
Okay.
So he himself is stated.
Reflect that way.
Lordship. So scene 1 is Lordship given.
Anything else, Mr. Hanbhai?
Nothing.
Yes.
The thing, first of all, I would like to submit that the statement of the accused at this stage is not admissible. In 482 also, that your lordship cannot take note of, because whatever they have not relied upon, that in their case diary, this lordship cannot look into. At the time of the consideration of the bail, that is irrelevant. But while causing of a charge sheet or the consideration of charge, that is not relevant.
Yes. Anything else?
Regarding the 4 lakhs, he says that is not reflects that or what is the rupees 4 lakhs and for which purpose 4 lakhs is why it was 4 lakhs is reduced. कम हुआ.
There is no indication that that is a bribe.
Pankaj Chauhan is from GR Infrastructure Projects. GR Infrastructure
Yes,
Project was the auditing.
No, he's our manager, Lordship, Pankaj Charan.
No, but that company was entrusted with
Pankaj,
He was there.
Aegis was the auditing company.
Aegis. Okay. 4 lakh was paid to whom?
To the Alok Kumar. From
By?
by GR. Pankaj sir is a manager, deputy manager or something. He's an employee of.
What was the purpose?
Purpose for releasing the bank guarantee, for smooth passing of the bill, all these things, Lordship.
But bank guarantee.
They are randomly, the officials of NH Highway Authority, they are randomly taking money for various means, Lordship, for passing of the bills, for passing of the bank guarantees, for smooth performing of their works, for everything, not only Alok Kumar alone, Lordship, other officials also. So from the telephonic conversation, it reveals, Lordship.
Your submission is that conversation does not reveal the
Not
purpose.
regarding the bribery.
Okay. Heard.
Lordship, one more submission regarding 482, Lordship. I have already made my submission. Your Lordship, you have to find out whether there is a rarest of the rare case or not. Firstly, the power under 482 has to be exercised sparingly in the rarest of the rare case and with some circumspection, Lordship. So here in this case, Lordship, the Supreme Court time and again is stating, Lordship, if prima facie case has been made out after reading, bare reading of the FIR and charge sheet, then it is not be wise to quash the FIR or charge sheet, Lordship. That is the ruling of Honorable Apex Court, and that apart, Lordship, Bhajan's guidelines has been given. I have already relied upon, Lordship. The Lordship have to go, will have to go through the FIR and charge sheet. Clearly, a case under section 13(7) has been made out. And Lordship, one more judgment I have recently come up, Lordship, regarding framing of charge, though it was fixed for framing of charge, not it was not yet been done. If in the at the time of framing of charge also, well, the documents and the materials relied by the defense are not to be looked into, Lordship. At the time of framing of charge, Lordship, the prosecution has to be prosecution's document and material has to be looked into for arriving into decision to frame the charge against the accused, Lordship. Here, in this case also, Lordship, they have certain relied certain documents. Those documents, your Lordship, cannot have to look into. That is the judgment, Lordship. I'll place the judgment. It's a 2023.
I don't before Sanjay Man is in the link. Today he entered.
BC link.
BC.
That is, I'll read the head note, Lordship. At the time of framing of charge also.
No, your submission is that the rules, the contract which they,
At the time of framing.
the contract which they relied upon, the clauses of contract.
Contract is a part we have relied upon. That is a relied.
They have also relied upon
Yes.
the same. They have
Other than the document which has been relied upon by the prosecution, if they have submitted, those documents cannot be looked into.
they have only relied upon the
Contract.
clauses of the contract,
Lordship.
showing what is their duty.
Lordship. We are not disputing that, Lordship.
Okay. Yes, Mr. Man. You have-
Yes, my lord, I am sorry, I was stuck in some other court, my lord. I was under the impression that my lord will give us time at 2 o'clock. In any case, my lord, my learned friend has read one transcript which is, my lord, I will like to, just for a minute, my lord, we wish to read, my lord.
Just a minute.
Yes, my lord.
Before you start,
Yes, my lord.
Mr. Hallo, you have anything else to submit?
No, Lordship, I've done.
So you give that judgment
Lordship, I'll give it to you.
and have you relied upon any other document which is not not relied upon by the prosecution side?
No, my lord. We had only submitted the documents which are part and parcel of the charge sheet that they have filed.
You have taken this court to the clauses of the contract
Yes, my lord.
to show what is your duty.
Yes, my lord.
Okay, now what is your submission?
Now, my lord, my learned friend read some communication transcript of alleged phone tapping that is dated 14/4/2022.
Date he has not mentioned. How you?
That is Pankaj Charan, Mr. Sushil Kumar Agarwal, and
Pankaj
allegedly.
Charan, Sushil Agarwal.
Yes, my lord.
Three persons.
Yes, my lord. Yes, my lord.
Okay, okay. Yes, he has relied on those.
Yes, my lord. He read that specifically. Now kindly see, my lord, what it says. He says 4 lakh rupees ka kaam hua na. He says his interpretation is that I have taken money. No, but kindly see, my lord, I will read it. It is SOS, COS, additional work which was assigned. I will read it in complete. What he has done is he is reading it in piecemeal form.
What he says, 4 lakh rupees ka kaam hua na.
I will read just kindly have the document, my lord, for a minute, my lord. Kindly have that document.
One of the.
Your submission is that it does not indicate that this money was taken by him.
No, it is not regarding taking money, my lord. It is the additional work, my lord. He says, I will read it, my lord. It was in relation to additional work which was assigned to him, which was done by the contractor. And in that regard, he says, I will read it in complete, my lord.
Yes. Yes. Not only relevant part you made it.
Yes, my lord. एक सारे बिल को मैं देख लिया वो ही we people are doing our job, not your job only. नहीं सर अच्छा ये मेरे को this is not serious, my lord. If my lord will read the alleged phone tape, it is COS, my lord, the additional work assigned to.
What is the meaning of COS?
My lord, it is I will read from the contract, my lord. It is mentioned in the contract. It is COS is additional work that was assigned.
Okay.
It is not serious matter. It is COS may say.
Serious COS may say.
So COS may say.
That means from the COS.
In their own transcript, in their documents they have filed, they have made the correction. It is not serious matter. का 4 लाख रुपए का काम हुआ ना. It is COS में से.
Okay.
COS I will read, my lord. It is the additional work that is incidental to. Then he says, sir. So now what he is saying is the COS 4 lakh रुपए का काम हुआ. He is not saying that I have received 4 lakh rupees or 4 lakh rupees was paid to me. It is in regard to COS work that was additional work that was assigned, and for that he was paid. Bills are the talk is in regard to the bills, and it is only in regard to COS additional work that was assigned to him. I will read from the relevant page of wherein it is mentioned how we see what is COS. If my lord will read this whole thing, whole communication is in regard to that only. He says, my additional work is done. I am ready to give bank guarantee of such a certain amount. You release my bank guarantee. It is not regarding any receipt of money. This is wild imagination. And if this document and this,
Just a minute, Mr. Haloy,
Lordship.
in this transcription,
Lordship.
he's saying, अच्छा ये मेरे को COS में से 4 लाख रुपए का काम हुआ ना. He's only putting a query whether this 4 lakhs.
Come हुआ. Come and come. Come means less.
नहीं, काम हुआ ना. Work has been done on. It is not काम हुआ. You are interpreting it as it is 4 lakh is less.
Less, yes.
Okay.
अच्छा ये मेरे को serious matter का
Not serious.
COS was not, it was written by pencil.
Who has written?
I don't know, Lordship.
It
Maybe
has to be the
by
investigating.
by the IO.
I only.
4 lakh rupees का कम हुआ ना. तो कम KM. It may less also. Serious matter का 4 lakh rupees का कम हुआ ना. I could keep over. I am also in a dilemma. The 4 lakh rupees का काम हुआ ना. अच्छा ये मेरे को serious matter का.
It is not serious. You have corrected yourself. IO has corrected. You have to read either handwritten or the printed.
Lordship. But it was not, IO has not put any initial, Lordship.
Then this is a part of the case diary.
Yes.
Who will put?
Yes. Definitely by the IO.
It has to be by the IO.
By the IO. But why
It cannot be by the accused.
Definitely, Lordship. अच्छा ये मेरे को COS में से but it makes no sense, Lordship, if we go by the overwriting.
Yes.
अच्छा ये मेरे को COS में से का COS में से 4 lakh रुपए का कम हुआ ना. What sense does it make, Lordship?
I do not understand.
Then Lordship, CO has nothing to do with this 4 lakh rupees. अच्छा ये मेरे को serious matter का 4 lakhs का कम हुआ ना. That makes a sense, Lordship. It makes a complete sense if we read the sentence, Lordship. But if this COS में से, it makes no sense. अच्छा ये मेरे को COS में से का 4 lakh rupees का कम हुआ ना. This sentence makes no sense, Lordship.
No, it is not question of whether it makes sense or not. It is question of what was spoken.
Spoken. That
What
is
was, it was
the
whether,
sentence has to make some reflection, Lordship. The sentence has to make some sense, Lordship. They are speaking, Lordship.
yes.
If they are speaking and they are saying, if this Alok Kumar is saying, अच्छा ये मेरे
Then
को,
why this correction was made?
I don't know, Lordship. I'll have to ask Lordship. What is the meaning of this COS message?
Because you are heavily relying on this statement.
Yes, yes. I'll have to ask Lordship. Why he has written COS message and it was.
You
serious
ask,
matter.
you can ask, he is here.
No.
IO is,
He is the holding IO. The IO was subsequently.
you said that IO is here in Guwahati.
Holding IO, Lordship. He has to come. IO was transferred to some other department. There are many
You
departments.
can telephonically take this instruction.
Yes, yes.
You may telephonically take
Yes.
today itself.
Lordship. Give us 5 minutes time, Lordship.
I'll give you time. Let us hear Mr. Man.
Lordship. May I go out and take up the instruction right now only? I think.
Yes, yes. Who will hear what Mr. Man is saying in your absence? No, you remain here.
Okay.
After
Completing my.
completion of his submission, you take instruction. We will take it for this little part. We will take it up after lunch at 2
Yes, sir.
for that clarification. Yes, Mr. Man.
Yes, my lord. So now, my lord, this is in regard to the additional work that is incidental to the project, and that is how it is. And it is duly communicated and duly reflected in the letters also. If my lord will have that, there was some additional work of 38 or 38 lakh odd was there. If my lord, I will take 5 minutes of the honorable court after going through the file wherein it is mentioned. So the wherein BG of 4 lakh rupees is to be given. That is, my lord, additional for 3.5% of the additional work. That is, this is.
No, Mr. Man.
Yes, my lord.
Because it is spoken by you only.
Yes, ma'am. COS, my lord, I will come and produce what is meant by COS, my lord. I was just looking into the agreement COS is mentioned, my lord. There is a specific mention of the abbreviation COS. It is duly reflected in part of the agreement between these entities.
I want some time to go through it.
My lord, because this is bulky document, my lord, right now, I am just trying to.
You also go through it, Mr. Halloy also. We'll take it up at 2.
Yes, my lord.
We'll take, because only small.
Yes, my lord, or only for that limited purpose, my lord.
If we assume for argument's sake, what Mr. Man is saying, that it is for COS. Even if we assume and we take the COS here, then what does it mean, Lordship?
His submission is, Mr. Alok Kumar, the petitioner is querying that the additional work which was given to you for 4 lakh, whether that work is completed or not. That is,
yes.
And it does not imply any bribe taking or anything.
But
that is his submission.
Whether they can show us any document whereby they were given additional work.
Yes.
Yes, I will do that.
Additional work apart from the
I will do that.
Let him show.
Okay.
Yes.
At 2.
Yes, my lord. Grateful, man.
Order item 20.
May I please, Lordship, as per office noted dated 15 March 2024, Lordship, step was not taken, Lordship. Lordship, kindly allow 2 days time, Lordship. I will take steps, Lordship.
Heard, Miss
P. Adhikari.
P.
Adhikari.
Adhikari, learned counsel for the petitioner, who prays for some more time for taking steps for issuance of notice on respondent number 2. Respondent number 2 through registered post with ID. The prayer is allowed. The petitioner shall take steps for issuance of notice on respondent number 2 within 3 days from the date of this order. The notice is returnable after 4 weeks. Let this case be listed after 4 weeks.
Item 21.
Yeah, please, the lordship. My lord, here the interlocutory application is for condoning the delay of 6 days only, my lord.
This is a criminal appeal.
Criminal appeal, my lord. Yes,
why the delay was caused?
My lord, the lady, wife of the applicant, came in with incomplete document. That she did not got the wakalatnama duly signed by the jailer, and in that, because of that, there was a delay of 6 days, man. That may be condoned and managed conviction of
Mr. Bush.
6 days.
Heard, Mr. N.
M.A. Chaudhary.
M.H.
M.A. Chaudhary.
M.A. Chaudhary. Heard Mr. M.A. Chaudhary. Also heard Mr. K.K. Bushro. K. Bushro. Learned additional public prosecutor. This interlocutory application under section 5 of the Limitation Act, 1963 has been filed by the applicant Nurul Ali alias Para, praying for condoning the delay of 6 days in lodging the connected appeal by which he has impugned the judgment and order dated 13/12/2023 passed by Lanet's additional session judge from Special Judge POCSO Kamrup Aminggaon in special case number 75/2022, whereby the applicant has been convicted under section 18 of the POCSO Act, 2012, and has been sentenced to undergo simple imprisonment for 2 years and to pay a fine.
On 2023,
What is your name?
I.A. Hazarika.
Because on last date, also an adjournment was sought for.
We did not, that the respondent side, right?
Both time respondent or two time.
Who is appearing for respondent? Public.
That two occasion they took time, my lord. 8-2 and 7-4.
No, last time it was moved by one Miss N.T. Manung.
Yes, they are respondent.
Respondent.
Yes, ma'am.
Okay. Heard Mr. I.A. Hazarika, learned counsel for the appellant, who also heard Mr. K. Bushro, learned additional public prosecutor. None has appeared for respondent number.
State or party, no. Party night, we are not party. Also, we are not the party into the matter. Private. Good night. Good night.
This is a criminal petition.
Criminal appeal.
But the record says that it is a revision petition.
Initially, it was filed as a revision, but later on, it was converted because there was mistake, madam.
It was converted into an appeal.
Appeal, ma'am. Let it be on lordship after election, because in election also.
State is a party.
State is not a party, lords.
Number 4, because
Number
this
4.
is an appeal,
Yes.
it has to be a party.
Yes. Okay.
None appears for respondent number 1 and 2. 1, 2, and 3. Learned Mr. I.A. Hazarika, learned counsel for the petitioner, has paid for an adjournment on the ground that he is not prepared to argue this case today and seeks some time for preparation. Considering the fact that none has appeared for respondent number 1, 2, and 3, and also considering the fact that you are ready, you are also not ready.
Lordship.
Considering the fact
Let
that
it be on 30, because after elections, because he is also going my. He also will be outside.
you are contesting.
He's the.
My senior
he's
is
a voter.
contesting ASL Chaudhary.
Okay.
On 38th.
Okay, let this case be listed again on
30th of April.
30th April. The prayer is allowed. Let this case be disturbed on 30th.
Matlab, the registry will reflect the name of PP in that person's
The
lordship.
registry shall also reflect the name of the public prosecutor or respondent number 4 in this case, henceforth.
Much cleaner.
Yes, Mr. Halloy.
Lordship, with regard to that statement, Lordship, I have taken verbal over phone, Lordship, so I do not want to take risk, Lordship. Over phone, I have taken an instruction, and if I made some statement before, it will be recorded. So I don't want to take a risk, Lordship. Who has written, let the IO clarify, Lordship.
What do you propose?
Then I propose a date, Lordship. But I'll write and let them clarify.
Inform them. Okay, then let us fix a date.
Okay.
Money.
Huh?
Mr. Man,
Made, please, Your Honor.
no, before you, whether it is COS may say or serious, the word whether it is COS may say or serious, Mr. Halloy is seeking some time.
He may, my lord, but let me clarify. If my lord will see, it will be clarified from the document that my learned friend is relying on. If my lord will have,
You can clarify, but he has to be given,
so my lord, it
it
will
has
be,
to be 1 day, 2 days time only.
it will be clarity in his mind also regarding this COS, my lord. If my 2 minutes, my lord, I will take.
Yes, you may clarify, you may listen to him also,
Yes.
so that you can ask IO.
Yes,
that
Yes.
he-
Yes.
No, no, IO is saying that it is COS.
It is COS.
It is COS.
Okay.
Even
But you
then, I
want to
get
written
it in
confirm.
writing. I want to get it in writing.
Okay.
Because if I submit, I have no
Because
proof,
there is no initial.
no nothing, Lordship.
Okay.
No initial, nothing, Lordship,
Okay.
and no document also with me.
Okay.
Therefore,
Then Mr. Man, what COS means?
Yes, my lord. If my lord kindly see, my lord, if my lord can have page number 162 of, my lord, it is change of scope. 162 of petitions that we find, my lord.
Mota. Pura mota bada. Right.
change of scope. Change of COS.
Change of scope.
Change of scope.
Oh, change of scope.
Change of scope.
150.
150,
162, my lord.
162.
162.
Yes.
Change of scope, my lord. The authority may, notwithstanding anything to the contrary contained in the agreement, requires the contractor to make modifications, alteration to the work, change of scope before the issue of completion certificate, either by giving an instruction or by requesting the contractor to submit a proposal for change of scope involving additional cost or reduction in cost. Any such change of scope shall be made and value in accordance with the provisions of this article. So, my lord, COS means change of scope.
Okay.
And then, my lord, will have similar meaning is attributed on page number 229. Then, my lord, the question arises whether the change of scope was awarded to this contractor in this present case or not. And what was the effect, my lord?
Yes.
If my lord will have page number 602 for a minute, my lord. This is our rejoinder, my lord. On this also, my lord, continue, my lord, in this petition on page number 502.
Page number?
502, my lord. 502.
502 is rejoinder.
No. Of the main petition.
Yes, 502.
This is a letter, my lord, letter by the authority engineer. That is starting from page number 500.
Yes.
Now, my lord, on this is successful completion of the ongoing COS work by the contractor. On top of page number 502, it is mentioned, my lord.
Yes.
Then, my lord, on page number 501, if my lord will have.
Yes.
Page, last para. In view of the ongoing COS work and pending certification of the final statement of the total payment work article by the authority engineer, as well as issue of discharge under article, so the undersigned hereby recommend for the release of major part of bank guarantee. Similarly, it is also fourth para from the bottom, my lord. It is so mentioned, my lord. Whereas in the present case, due to completion of work, due to the execution of the balance work and COS work during the OM period. It is also so reflected in the note, my lord. Office note. If my lord will have page number 511.
COS work means additional work.
Yeah, COS, my lord, change of scope. It may be reduction or it may be addition.
Some alteration. In the
Yes,
original work
some
order.
alteration in the work because my lord, situation is fluid and there may arise certain unforeseen circumstances. There may be reduction or there may be extension. In the present case, my lord, there is a document. If my lord will have.
Okay, so your submission is that the petitioner was speaking to Mr. Pankaj Charan regarding this additional work.
No, my lord, it is also documented. I will come if my lord will have only give me 2 minutes, my lord. Then if my lord will have page number 602 of my rejoinder.
Yes.
602, my lord, the letter is commencing from page number 602. If my lord will have page number 604, clause C, subpara 2, on page number 604.
Yes.
It says COS for repair had not been, my lord. During the OM period, the following COS orders have been issued to the contractor by the authority.
Yes.
One is COS for implementation, that was during the contract period. Then, my lord, on part 2, part 2, COS for repair, rehabilitation of major bridge at kilometer 140.20, so and so village for an amount of rupees. Kindly see, my lord, 38 lakhs 84,800. Kindly see the date also. With a date, order dated 12/4/2022.
Yes.
Milord, the transcript that my learned friend was reading was of 14/4/2022. Then, Milord, kindly see what is the GST. What are the GST charges? It is on para number 6, Milord. If Milord will have.
What it implies?
Milord, kindly for a minute.
No,
Just
when the mention of this
4 lakh rupees. 4 lakh rupees.
Project 3884,800 dated 2012
But
2022.
yes, my lord.
And they spoke on 14/4/2022. What it implies?
It implies, Milord, kindly see, it implies, Milord, that the talk was in regard to this SOP, COS, and rupees 4 lakh is, Milord, kindly see, the GST is at 12%, Milord. On para number 6, Milord, it is specifically mentioned the bonus amount due to the contractor include GST of at rupees 12%. Comes 12%.
Okay.
So, Milord, if 38 lakh 84,800 is to be GST is to be calculated, Milord, it will comes to 4 lakh rupees only. And in this conversation, allegedly recorded by CBI, it says 4 lakh kam hoga. So 38 lakh rupees is the scope, and GST chargeable is exactly will be around 4 lakh rupees, Milord. So this is not what is interpreted by CBI at this stage. It is in regard to this only because this is communicated to the entity only on a letter that dated 13th, and talk is
Which page you were referring to just now?
Page number 604, Milord.
It says that bonus amount due to contractor including GST.
So, Milord, this is in regard, specifically I am mentioning is GST is chargeable is 12%. So GST.
What is this bonus amount?
Bonus is, Milord, additional amount for if the project is prepared earlier. Then, Milord, as per the policy of the government of the authority, there are certain bonuses are awarded to the contractors.
Otherwise, the amount comes to 4 lakhs.
GST will become to 4 lakh rupees only, Milord, on this additional work, because this was to demonstrate that the GST chargeable at that point of time was 12%, Milord, of the work.
But COS, Lordship, by this document, 2 COS has been implemented.
Yes. One is
COS.
One is
6 crore.
Yeah, 6 crore rupees. That was earlier.
For COS for implementation of hybrid so and so in lane number for an amount of be 6 crore 21 lakhs.
Kindly see the date.
7/8/19.
Yes.
For repair so and so.
So it earlier change of scope was earlier awarded was 7/8/2019.
Yes.
And then, Milord, seconds was awarded only in 12/4/2022.
So your submission is they were speaking regarding second.
Yes, of course they were because it was awarded only on 12th, approved by on 12th, and communicated to the company contractor on 13th. So there was this communication that was the talk. And it also says COS में से 4 लाख रुपए 4 लाख कम हो जाएगा. And if
one of the submission of the special public prosecutor was what purpose the petitioner has talking to the officials of the
NHI.
Not NHI, GR infrastructure.
Milord, my posting, see what we are concerned here, I'm not here as as a government officer. I am here as a party to a contract. There is no slave or master relationship. Here, both the parties are entering into an agreement. Contract is between two parties. One is the contractor, one is NHI. I am also bound by to comply with my terms of my obligations towards the contract, and the contractor is also liable to complete. And secondly, my lord, the road is to be constructed and repaired, my lord. I have to communicate with all the officers of NHI, also with the contractor and also with the authority engineer, because it is my responsibility to see whether the work is done or whether the road is motorable or not. Because, my lord, I have certain documents wherein I had been communicated by.
GR infrastructure.
Yes, ma'am.
It is not a party to.
No, they are the party to the contract, my lord. They are the contractor.
The party. They are the contractor who.
Yes, my lord. They are the authority. They are the contractor.
Okay.
So this agreement is between NHI and GR contractors. So I have to communicate and talk to them, my lord, on the regular basis.
Regarding progress of the work.
Regarding progress of the work, and also regarding release of whatever bank guarantees are also there, because it has to be approved by me on the recommendation of the authority engineer and also by the project director. We live in a fluid world, my lord. If the work is not communicated, and I have to also comfort them that your work will be done. It is my responsibility to see through that work is executed. If authority engineer or for that matter, the contractor is not doing the work, the burden is on me to ensure that the road is motorable and repairs are done in a time-bound manner.
Okay.
And my lord, only for a short while, my lord.
Yes.
This note is also this information is also available in the note office note regarding the bank guarantee regarding this change of scope, additional work that was awarded. And change of work was not awarded by me. It was awarded by the competent authority sitting in Delhi, my lord. It was approved by GM Technical. That is also part of the charge sheet. That the document is also part of charge sheet. It was communicated to the company by the letter dated 13/4/2022.
Okay. The submission of special public prosecutor was that as the discussion between you and Pankaj Charan, during discussion, there was mention of ₹4 lakhs and there was mention of something less. So it indicated that you were paid that money by. That is your.
Yes. From
because
the
one of the co-accused also later on stated. On that, you have made other submissions, but they are relying on this telephonic conversation as incriminating materials.
This telephonic conversation, my lord, itself clears the age that is stated by my learned friend. If my lord will have, kindly see, I read this, my lord. If my lord will have this communication allegedly recorded by CBI. 1, 2, 3.
Okay, I have understood. Your submission is that this conversation was between two parties to the contract, and this is something which is normal and regular. And this was in relation to a additional work which is known as COS in.
Yes, my lord.
So he used this word COS, and this related to the second COS.
Yes, my lord.
The amount of which was, after adding GST, was equivalent to 4 lakhs.
Yes, my lord.
Therefore, he was querying about whether work has been done or not.
Yes, my lord. Kindly see, my lord, fourth line from where my learned friend read.
The transcription.
Yes, my lord, of the transcript. It specifically says,
Yes, read.
सर मेरा एक्चुअल क्या है COS का, ये तो चलो कोई नहीं एक्साइटमेंट नहीं है. He here itself in the writing he is mentioning about COS.
No, that is the difficulty. Had it been type form, I would have not.
No,
raised
he
it.
will make clarification.
Yes, therefore I'm taking
Okay,
time.
your point I have understood.
Yes, my lord.
The PP, special PP also have understood this
Yes.
submission.
Yes, sir.
That it is in relation to an additional work.
Yes,
But you will clarify it in
Yes.
writing.
yes, that is the thing.
Anything else?
That's it, my lord. And earlier also in the month of February, my learned friend was insinuating something to me, which is neither part and parcel of the charge sheet. And subsequently, in the month of May 2022, I had no work pending as far as this company is concerned. And my lord, my learned friend was confusing with accused number 2, who is Alok Das, with me, my lord.
Yes, who is Alok Das?
He is the accused, he is the person who was arrested taking
Somebody
Deepak,
called
Deepak,
Alok Das
Deepak Das,
also?
Deepak Das, my lord, sorry.
Deepak Das, not
Deepak
Alok.
Das.
But what happened? The Pankaj Charan in his statement, while referring to you according to special public prosecutor, he has not referred to your name Alok Kumar. He has referred name of Alok Das, which according to the public prosecutor, he is referring not to Alok Das, he is referring to you. That is
No,
his.
my lord, that Das, Mr. Das is the accused number 2, Deepak Das. So he is not referring to me.
He could.
So
Because
that is, my lord, wild imagination drawn by my learned friend.
So I'm making my submission on the basis of record. These things are creating a confusion in the mind of the court also, in the mind of the public person, myself
But
also.
there is no one called Alok Das.
There is no one called
It
Alok
could
Das.
either refer to Alok Kumar or Deepak Das.
Deepak Das. These are the two persons.
And Deepak Das was arrested, my lord, taking a bribe.
Submission is Alok Das and Alok Kumar are not one and the same
Same
person.
Yes.
Okay. Then we will fix it for, reserve it for judgment.
Yes, Lordship. I'll get it clarified. I'll place before this honorable court on one day, Lordship.
Or or if you take a short date, we can fix it for on that date.
Today is 19, Lordship. 19.
Because
Let it be on 27, Lordship.
so on that day we will reserve it for judgment.
Right.
Because what you submit, we don't know.
Yes, sir.
Mr. Maan may have to say something.
Yes, sir.
Yes, my lord.
From my telephonic conversation, he is correct, Lordship. But let me get it in writing, Lordship. Only on that point, Lordship.
Mr. M. Aloy, learned special public prosecutor, CBI. Also, our Mr. Sanjay Man, learned counsel to the petitioner. The hearing is concluded. However, learned special public prosecutor prays for fixing this matter on 27th of March 2024, so as to enable him to submit in writing regarding the clarification relating to the
Intercepted call.
the transcription of intercepted call between the petitioner and one Pankaj Charan.
Dated
Intercepted call dated
14/4, I think. Lordship.
14/4/2022 between the petitioner and one
14/4/2022.
co-accused. Pankaj Charan is also
Pankaj Charan, Alok Kumar and SK means Sunil Kumar Agarwal. Between these
Pankaj
three.
Charan, Alok Kumar and Sudeep Kumar Agarwal. The prayer is allowed. Let this matter be listed again on 27. 3/24 as part of letter.
Harif.
Grateful, man.
Thank you. Ekita mix of कागज रहते हैं।
With regard to lordship, item number 29, 30, 31 lordship, the series lordship. 29, 30, 31, 32 lordship. Series of cases lordship. DRO lordship, he expired lordship. I don't know whether counsel for the accused person will be present or not.
Who is for the
DRO.
appellant? You are for the appellant.
Lordship, I'm in item number 32. Senior counsel Jet Kama gave me instruction to take adjournment.
Who is Miss E. Ahmed? In item number
29,
29 to 32. Now, Mr. M. Haloy Learned Special Learned Standing Counsel CBI. Special Public Learned Special Public Prosecutor CBI, who informs that Mr. D.R. Gogoi, who was the engaged counsel for the appellant in criminal appeal number 143/12, 144/12, as well as 145/12, has expired. Stop. None has appeared on call for the said appellants. On the other hand, Ms. P. Soikia,
On behalf of Jet Kama.
submitting on behalf of Mr. Z. Kamar, Learned Senior Counsel, appearing for the appellant in criminal appeal number 151/2012, has prayed for an adjournment. As none has appeared in the three appeals in which late D.R. Gogoi was engaged, this court deems it proper to adjourn this matter today. Let this matter be, when should be listed?
The second week of April, any day.
Let this matter be listed after 3 weeks. 3 weeks.
Harif.
My pleasure, Lordship. In this case, Lordship, I file an IA was suspension of sentence because Lordship petitioner is suffering from various ailments, Lordship, and he was suddenly admitted in the GMCH, Lordship.
The report has come.
One report received. But Lordship, before that, the appellant was arrested, Lordship, on 15/12/2018. And thereafter, after examination of the witnesses, Lordship, he was convicted on 6/8/2022 under section, Lordship, 20B2 Roman 2C of NDPS Act, Lordship. As allegation was that, Lordship, recovery of contraband of ganja, 22 kgs, Lordship.
What was the sentence?
Sentence was 10 years.
10 years.
10 years. And from 15/12/2018, today is about, Lordship, 5 years, 3 months, 3 days, Lordship, 1,919 days.
Today, this
IA. Before your lordship, IA is there, lordship, for consideration of bail, lordship. Because lordship, in this case, what I found, 6 witnesses are examined, lordship. 6 witnesses are examined, including the FSL officer, and 9 numbers of documents exhibited, lordship. PW1 is the seizing officer, and 2 is the team, is the head constable of GRPS, lordship, who alleged that they were intercepted the accused person with the checking team inside the Rajdhani train, lordship, the morning hours. Then thereafter, they brought to deboarded from the train, and they kept detained the person there, platform number 1. Then they informed to OC GRPS. Then OC GRPS has stated, lordship, information forwarded to the DSP. Then DSP deputed PW1 for search and seizure. Then PW1 reached the platform number 1, and all the formalities regarding search and seizure completed there, lordship. Then thereafter, the search and seizure completed, and samples are also collected from there. And after that, with the contrabands and the accused, brought to the GRPS and handed over to the OC. So here, first and foremost argument is that, lordship, compliance of 52 is not there at all. Though they have stated one inventory prepared, but inventory regarding what, lordship? That is regarding application before the court for certification of correctness of the inventory, that are not there, lordship. That is denied by the investigating officer.
52.
52A, which is mandatory. If any sample collected at the spot.
So today, are you arguing the main appeal?
No. Before.
So that is your case in the appeal? That
Yes, appeal.
52
Because, yes.
A has not been followed.
Lordship. Then, lordship, independent witness also is not there, lordship. They have not called for any independent witnesses, lordship.
Either was made in the
Crowded place, platform number 1.
in the train or in the
No,
platform?
the person, they have stated that the person found inside the Rajdhani train. Then after getting the person, they brought down the person to the platform number 1. They detained the checking team. They detained the person there. Then PW1 came there, and she intercepted the person, and
Later on, he has PW1 never boarded on the train.
No, not at all. It is nearby to the GRPS lodge. platform number 1 and GRPS is
Then
there.
PW1 is the only witness and other seizing witness.
Other seizure witness, other as PW2, 3, and 4. They are the team member, and they are the seizure witness, and they are officers lordship. All are constable lodge.
What they have stated?
They have stated that they were in the checking team, and they found a person inside it, and in which seat number which he was sitting, that was not mentioned in anywhere else. Because Rajdhani, they realized that he was inside the Rajdhani. In Rajdhani, it's not possible to travel from Dimapur to Guwahati without booking any seat, lordship. So thereafter, they found a person with a bag. On suspicion, they intercepted the person. Then they brought down the person to the platform number 1. Platform number 1 is a crowded place, lordship. No witnesses called for from there. And then subsequently, they intercepted, the PW1 came there, and they weighed all the seized materials and seized that. And samples also prepared at the spot. That was produced before the court, and that sample sent to the FSL, which is completely violation of the 52A of the NDPS Act. So for that, lordship, I found a suspension of sentence to that regard also. And the lordship, if that is not produced before the court, samples not produced before the court, then that cannot be considered as a primary evidence. If even after producing all the seized material before the court, they produce all the seized material before the court in an open condition. All are not in a intact condition, that seal packed the seized contraband were in a sealed packed condition, Lordship. That is not the case in the present case. So for that, Lordship, the person is convicted for about 10 years and today he completed 5 years, 3 months, 3 days. Half of the punishment already completed, Lordship. And what I found, Lordship, here. Okay. Okay. May I read the deposition? May I read the deposition of investigating officer or sealing officer? PW1.
No, what is your ground for suspension of sentence?
Suspension.
What main grounds?
Main ground is Lordship.
52A is not complied.
Not complied with. So then Lordship, my ground is Lordship. Inventory not prepared as per 52A.
Sampling was not done in front of magistrate.
Yes.
What else?
And then no application for correction of the inventory under 52A, Lordship. That is very essential. As per Act, Lordship. Lordship already perused that 52A. As your Lordship aware about that. 52A, Lordship. (52A) subclause 2. May I read, Lordship?
Yes.
Where first part is regarding officials and contrabands, Lordship. I am reading 2, subclause 2, where any narcotic, drugs, psychotropic substances, controlled substances or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred in subsection 1 shall prepare an inventory of such. Officer referred in subsection 1, these are the officers also, shall prepare an inventory of such narcotic, drugs, psychotropic substances, controlled substances or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic, drugs, psychotropic substances, controlled substances or conveyances, or the packing in which they are packed, country of origin and other particulars as the officer referred to in subsection 1 may consider the relevant to the identity of the narcotic, drugs, psychotropic substances, controlled substances or conveyances in any proceeding under this act and make an application to any magistrate for the purpose of certifying the correctness of the inventory so prepared, taking in presence of such magistrate photographs of such drugs, substances or conveyances, and certifying such photographs as true. C, allowing to draw representative samples of such drugs or substances in the presence of magistrate and certifying the correctness of any list of samples so drawn where an application is made. Subsection 2, the magistrate shall, as soon as may be allowed the application, notwithstanding anything contained in Indian Evidence Act or the Code of Criminal Procedure, every code trying an offense under this act shall treat the inventory, the photographs of narcotic, drugs, psychotropic substances, controlled substances, or conveyances and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offense. So in our case, the PW1, she is not the authorized officer to collect the samples because PW1 is the seizing officer. She is not the officer empowered under section 53 as per 52A1.
Who are the officers who are empowered?
They are the officer in charge as per 53. Lordship will find at a 53, section 53, powers to invest officer of certain department with powers of officer in charge of a police station. May I read, Lordship?
No, 52 speaks about
52 in subclause 2, the officers, where any first two lines, Lordship, any narcotics, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. Then only, Lordship, that officer will conduct other pursuits. After search and seizure, it is the duty of the seizing officer.
either OC or 53-1.
53-1.
Okay, what happened in this case?
In this case, Lordship, the seizing officer, she herself collected, seized the entire contrabands, and thereafter she collected the samples at the spot, which is contrary to the law. Because after search and seizure, she has to deposit before the officer in charge, and officer in charge carry out all the thereafter formalities. After all the formalities, he has to.
Seizure was done in this case by Assam Police.
Assam Police,
or GRP.
GRPS. GRPS. Guwahati Railway Police Station.
Guwahati Railway Police.
That is under Assam Police Station.
So it had, according to you, it should have been produced before the officer in charge of GRPS.
He is PW6 in this case. It was the duty of the PW1 to produce all the seized articles. She had produced all the thing before the officer, Lordship, but she has collected the samples at the spot and other formalities observed at the spot. After collecting all these things, produced before the officer in charge, and then officer in charge, without doing anything, produced before all the things before the magistrate, without filing any application on the 52A. And thereafter,
Whether inventory was prepared.
no, see, they have exhibited one document as inventory, but that is not the inventory as per 52A.
Why?
Because Lordship, kindly see exhibit 2. That was denied by the PW exhibit 3, PW6. No inventory was prepared in this case.
What is exhibit 3?
Exhibit 3 is the inventory list they have stated. See the inventory, Lordship. They have only stated inventory. It is denied by PW6. No inventory was prepared in this case.
PW6 has stated that no inventory was
prepared.
Okay.
So it is prepared by PW1, she has stated. But it is not as per the procedure laid down in 52A to subclause 2, Lordship. So in this case, this criteria has not fulfilled, Lordship. Then thereafter, what happened, Lordship, in this case, it was in the crowded place. If it was so that he was present at that particular time and with the contraband, Lordship, it was the duty of the officers to collect the independent witness from the place. No person from the railway station or
PW1 was the independent.
PW1 is the GRPS officer.
PW1.
Yes, Woman Sub Inspector of GRPS.
234.
234 also it's constable from GRPS.
They are in the seizing team.
Seizing team.
But PW1 have arrived there later on.
Later on the
But he is also a GRPA.
Yes, all are the GRPS officials.
Okay.
Then what happened, Lordship, in this case, 57, up, which is also 57, Lordship, after completion of after completion of all the search seizure formality, it is the duty of the officers to submit a report under 57 for report of arrest and seizure within 48 hours.
To the immediate superior.
Yes, that was not complied in this case, Lordship. For that purpose, Lordship, for a moment, we need to read the cross part of the PW6, Lordship.
Whether non-compliance of 57 is fatal.
Yes, it's a mandatory provision, Lordship. Test court in several cases.
You have authority to show that 57 is also mandatory.
57 directory, but the punishment is very stringent. That is why, Lordship,
But 57 is not mandatory.
directory, Lordship, not mandatory. But it should, they have to comply that procedure, Lordship. It's not the empty formalities, Lordship.
Okay.
PW6, Lordship. Nobody. PW6 for cross part, I am reading, Lordship. On the day of occurrence, I was posted as officer in charge at the GRPS. I have not sent in Exhibit 8 to my superior officer. Exhibit 8 is the information received by the officer, Lordship. That was reduced into writing, but that was not forwarded to the superior officer as per 42, Lordship. That is section 42 is one of the mandatory sections.
Yes, you may read.
Cross portion, my lord. On the day of occurrence, I was posted as officer in charge at GRPS. I have not sent in the Exhibit A to my superior officer, though it was informed over phone. I have not furnished any just document along with my search sheet to prove that that my superior officer received the information about Exhibit 8 over phone. I have not mentioned in my search sheet at what time the Exhibit 5 was prepared by my superior authority and sent to the seizing officer. In Exhibit 5, there is no mention as to when he received the information from me. I have not cited my superior officer as a witness in the charge sheet. Both in Exhibit 5 and Exhibit 8, there is no mention about the name of the accused or his seat number. I have not mentioned in the charge sheet at what time I myself and the seizing officer received the Exhibit 5, nor it has been mentioned in the FIR. Exhibit 5 is Lordship authority letter, which was given to the PW1 to conduct the charge. I have not mentioned in the charge sheet at what time I myself and the seizing officer received the Exhibit 5, nor it is been mentioned in the FIR. It is not a fact that Exhibit 5 and 8 are manufactured document and those were submitted subsequently. I have not annexed any certificate to the effect that the parcel which was sent for examination was under seal cover and it bears signatures of the accused and witnesses, though it was verified by me. I have not visited the place of interception after taking the investigation. I have not seen the signature of magistrate or the witness and the accused person in Exhibit 2, which is prepared by PW1. Exhibit 2 is the sketch map. In the Exhibit 2 sketch map, A is mentioned as the place of occurrence, but there is no description of the same. I have not made any clarification in the search sheet about the place of occurrence A. I have not verified personally the place of occurrence and place of interception of the accused, and I have not taken any evidence or witnesses from the place of occurrence or place of interception. I have not mentioned in the charge sheet as to where the accused along with the contraband were kept from the time of his interception, that is 5:45 AM till the preparation of the search and seizure at 7:20 AM. I have not mentioned in the search sheet the seat number of the accused and also what condition he was found inside the train. No train traveling tickets were seized from the accused in this case. I have not collected the passenger traveling chart during the investigations. The accused did not have any train ticket with him, but for that no case has been lost against him for the charge of traveling without ticket. PW1 has not made any independent witness during the time of seizure, nor there is mention of any independent witnesses in the charge sheet. There was no similar marking in the packet of the contraband as well as in the samples collected from them. I have not furnished any document or certificate as to whose custody the samples were kept since 15/12/2008 to 17/12/2008. I have not obtained any order from the court to send the samples to FSL. WPC Rupamani Kalita was entrusted the duty to deposit the samples to the FSL, but there is no mention as to who authorized her for the same. WPC Rupamani Kalita is not cited as a witness. The seized contraband was kept in the Malkhana in custody of
You
Sireskadar.
need not to read entire because we are today concerned only with the suspension of sentence.
That is why, Lordship, they could not establish their.
PW6
Is that?
in his cross, he said that 57.
To everything, he has admitted that inventory was not prepared, and also Lordship, 52 also admitted, and the contrabands, those samples from the contrabands, those samples were collected on 15, Lordship. It was forwarded to the FSL on 17. For these 2 days where they have kept, they have not established, Lordship, beyond reasonable doubt, Lordship, because they have not produced any extract copy of the Malkhana registered, and the in charge of the Malkhana also not made witness in this case, Lordship. So to that regard, Lordship, I would like to place
Sample was drawn on 15.
15/12/2020, Lordship, to 18. 15/12/2018.
Sample was drawn in the platform.
Platform number 1.
Okay.
Then
Not before magistrate.
not before magistrate. And then it was forwarded to the FSL on 17/12/2020, 2 days after 2 days, Lordship.
Okay.
So, and the samples which were collected at the spot, that was forwarded to the FSL, Lordship. In this regard, this is the latest.
Where is the law that sample which is collected in front of magistrate has to be sent to FSL?
52A, Lordship.
52A does not speak like that.
52A
52A says that that sample would be used as a primary evidence.
that sample only. That is interpreted in this 2023 judgment, Lordship. In
That-
all the judgments, Lordship, our High Court also,
That sample has to be sent.
yes, which has to collect before the magistrate.
Only
That
that sample can
sample.
be sent to.
Yes, that should be
Specific-
considered, yes,
Specific authority is there.
yes.
Show me.
It is in the judgment, Lordship.
Yes.
And the Mohanlal judgment is also there, 2016 judgment. It is clarified that all the things, Lordship. In para numbers, kindly go through the para number.
Which judgment you are referring to?
I'm referring 2023 SCC online list. At para number 15. Others are submission, Lordship. It is discussed the Mohanlal case also. May I read, Lordship?
Which para?
Para 15.
Now, before you read, today your limited submission is 52 not followed.
52
50
not followed,
57 not followed,
yes.
and
And Lordship,
no
he has
independent witness.
no independent witness. Then Lordship, other formalities is also there. Then Lordship, in this case, I got another judgment 2021. If the convicts, here Lordship, in pair number 6 in 2021, where the convict is sentenced for 10 years for having in his conscious possession commercial quantity of the contraband, he shall be entitled to bail. If he,
After completion of 5 years.
yes, he has already undergone total sentence of 4 years, which must include at least for 15 months of after conviction. Our also already completed 15 months, Lordship. Our own was. So this
Which
is
judgment is that?
21 Lordship. 2021. Lordship.
So these are your submission that as you have also you have also completed more than 5 years.
Lordship.
Therefore, you should be.
And the person is sick, Lordship. He is admitted several times in the hospital.
What is the ailment?
Ailments, Lordship, various ailments in the report, Lordship. Earlier, he has, because he was so severe diabetic patient during the trial also, it was severally reported to the trial judge. Thereafter, Lordship, what happened, because of diabetic, Lordship, it affected in the eyes. And we informed to the court, Lordship, regarding his eyesight problem. And there was no machine in the GMCH. That is why they could not operate the person, Lordship. That report is also there in earlier eye, Lordship. Because of that reason, early hearing started.
Today 2 eyes are fixed.
Eye, Lordship, in
What is this I 179?
24.
179 24 is for?
Is for bail, Lordship. Earlier we have filed a IA for 666 for his ailment, Lordship.
I 666 is for?
666 for he was suffering from eyesight problem, Lordship.
Therefore,
Lordship, the direction was there for.
No. What is the prayer in 666?
666 for providing the treatment, Lordship.
Okay. So
That was not disposed of. Because of that reason, no early hearing was started, Lordship. And now, Lordship, a report received, Lordship, flag mark is there, Lordship. Then several elements are there, Lordship. Because of that reason, Lordship, with any stringent condition, Lordship, at this stage, Lordship may grant the bail.
What you are referring to in 2023 judgment?
23 judgment regarding the 52A, Lordship.
Relevant paragraph is?
Relevant paragraph 15, Lordship. Other more judgments is also there, Lordship. 15 and a more 15 discussed, Lordship. 15.
Where is the finding?
15 then continue to it will continue till 17 and 18, Lordship. Because here Lordship, Mohanlal judgment where the law has been decided regarding 52A, Lordship. It was mandatory by that judgment, Lordship. So they have to collect. Earlier also in Noor Aga case also discussed regarding 52A, but thereafter this Mohanlal judgments came out, Lordship, and then Honorable Apex Court decided regarding 52A, Lordship. It is discussed here, Lordship. Shall I read it, Lordship?
Okay. And why?
Our case is exactly this, Lordship. Kindly for a moment, Lordship. Paragraph number 15, middle portion. Thus, the prosecution claims the sample were prepared even before the packets were sent to the station house officer. The submission learned counsel is that here in admitted PW to draw 2 samples from each of 2 packets. The contraband found in the hotel room and kept them in 2 separate plastic packets. Then these covers were sealed and then the remaining contraband was also sealed. Thus, the prosecution claims that samples were prepared even before the packets were sent to the station house officer. Exactly in our case, Lordship. Then the submission of the learned senior counsel appearing for the appellant so that a grave suspicion is created about the prosecution's case as this action by PW2 was contrary to the section 52 NDPS Act. Then the Mohanlal case discussed. In paragraph number 17 also, PW2 of drawing samples from all packets at the time of seizure is not
What 2021 says?
2021 regarding the bail also.
Where is the relevant?
In paragraph number 6, Lordship. Paragraph number 6, it was decided in Daler Singh versus State of Punjab. Thereafter, considering Lordship in this, we therefore feel that keeping in view the spirit of Article 21, following principles should be adopted for releasing of the prisoners on bail after placing them in different categories as under. Then it will come that section this 2, Lordship, Roman 2, where the convict is sentenced for 10 years for having in his conscious possessions commercial quantity of contraband, he shall be entitled to bail if he has already undergone the total sentence of 4 years, which must include at least 15 months after conviction. Our conviction.
No, this is what High Court did, what Supreme Court said.
Supreme Court case, Lordship. D.Y. Chandrasuran as.
No, this is an observation.
Thereafter, the observation is at paragraph number 12. May I read, Lordship? We appreciate the submission of Additional Solicitor General that offences under NDPS Act are serious nature and the case is at the post-conviction stage. Yet the court cannot be undermindful of the fact that appellant has undergone 8 years out of total sentence of 10 years. The appeal is unlikely to be heard early. In all probabilities, the entire sentence would have been undergone by the time the appeal is heard. The decisions of the basis on the basis of which the High Court Delhi has declined to grant suspension of sentence are at the highest the board guideline and cannot be placed on the same pedestal as a statutory indicate. With the pendency of the work in the High Court, it may not be feasible to expedite the disposal of the appeal within a short period. In the circumstances, particularly since appellant has undergone 8 years of 10 years of the total sentence which has been imposed on him, we are of the view that a fit and proper case has been made up for suspension of sentence under section 389 of CRPC. We accordingly allow the appeal and set aside the imperial order of the High Court. So right now, Lordship, in our case, we are seeking bail because he is in serious condition, Lordship, because of his ailments, Lordship. His eyesight already damaged, Lordship, and other also creatinine high, Lordship, because of this sugar also. Because of the
Eyesight not damaged.
It is reflected also color vision also not
Color blind.
Lordship.
He can see black and white.
That is the main because of this sugar, Lordship, high diabetic.
Okay. His eye.
Lordship.
Yes, Mr. Bushra.
Lordship, my learned colleague has already submitted her part. Lordship, I need some time to go through the LCR because she has explained some PWs.
My lord, last
maybe-
occasion, before he studying,
Yeah.
my lord, because of this urgency, Lordship, I made a request to Mr. Makhan Fukon to prepare this case, Lordship. I served a copy on Saturday, Lordship.
No.
There was no.
This prayer would have been allowed had you mentioned before she started.
Yes.
But after she has completed, now you are making this submission, it is not proper. Otherwise, we would not have wasted this much of time today.
Yes.
Also, matter maybe part had, maybe a short date may be given. That maybe that's my submission only. Maybe part had. Her part says only I will go through that. I've gone through the judgment and that part and the
No, her
law points
submission-
were
Her submission is 5 years completed.
5 years completed.
On that you have to counter. 52A is not followed.
Yes, Lord.
On that you have to counter.
Yes.
No independent Caesar witness.
Yes.
Though it is in a crowded place.
Yes.
Then though the actual Caesar was made on the railway wagon. This search was made in the railway wagon.
Yes, Lord.
And though there were in railway wagon also there were independent witnesses. the actual seizure was made after bringing it down in the to the platform.
Lordship.
Then PW6, then 57, which is directory, was not followed. Then he is suffering from various ailments.
Yes.
And he is colorblind and having other ophthalmologic ailment, which tilt the case for suspension in his balance. You have to counter this.
Lords.
When will you counter?
Any date, Lords. Short date, Lords.
Because
Tomorrow?
tomorrow at 2 Lordship. Tomorrow also. But my lord, several time I made request because of this person, Lordship, because
No, it has to be tomorrow only. Otherwise, I will forget.
Yes, yes, Lords.
yes,
Tomorrow, Lordship.
And he is okay.
now he is in GMCH, Lordship, to our information. They have practiced tomorrow. So we have practiced some more practical also. Nothing. I believe.
Third Mr. S.K. Nargis, third Miss S.K. Nargis, learned counsel for the applicant slash appellant. She has concluded her submission in the interlocutory application number
179, 2020. 179.
179/24,
2002.
wherein the prayer for suspension of sentence and releasing the appellant on bail has been made. Also heard learned additional Mr. K. Busho, learned additional public prosecutor, who prays for an accommodation to reply to the submissions made by learned counsel for the petitioner. The prayer is allowed. Let this matter be listed as part third matter tomorrow, that is on 20th of March 2020.
Tomorrow at 2 Lordship, that should be reflected in the ownership.
Tomorrow at 2 p.m.
Lordship kept it part hard.
It will be part third.
Obliged to
Deeply obliged.
Itu ह्याचा ini pas slip असतो. No, no. Itu 169, 179 type करो. परत नको. हे दुता 179 होतं.
The appeal against acquittal by the
Appeal against acquittal.
lots. The 2012 matter.
We are for respondent number 2.
Respondent number 2 was acquitted.
Two accused were there.
You are
Both
ready?
Both were acquitted.
Sorry.
You are ready for it.
My senior is not here actually, so can it be fixed for another day?
But since it is an old pending case of 2012, you are ready, Mr. Khan.
Okay.
We'll hear you. Tomorrow you reply. Okay.
This is available tomorrow. Or maybe taken up tomorrow. It's a very short matter. All this evidence are very small. 10 witnesses were examined by the London trial court.
On what ground?
Lordship court says that even though the position was they were found in position, but court said that there was no sufficient materials to prove that the sample drawn was from that particular seized materials. Although position is proved. And with regard to independent witness, court said that no independent witness was examined. So that there are so many judgments.
then we'll take it up day after tomorrow. You come prepared.
Yes,
Even if your senior is not ready, you come prepared.
yes, your lordship. Much obliged.
Day after tomorrow. How then Mr. SCKR, Learned Standing Council, NCD.
No, this is lordship from custom.
Standing Council, DRI,
Custom.
Customs Department. Also had Miss
N. Kashyap.
N. Kashyap, Learned Council for the respondent. On request of Learned Council for both the sides, let this matter be listed for hearing on 21/3/2020.
Much obliged.
At the flag monitor. The hearing open.
Please, my lord.
Yes.
Last order that I remember. Last order. My lord is pleased to see the last order. The matter came up for lordship's consideration on 23rd February. Please. My lord, the trial proceedings have been stayed since 5th of August 2016. That has prompted me to file an application on the last date of hearing for alteration and modification of the stay order.
No,
That was since
today,
granted
this case is fixed.
for hearing.
Hearing.
I'm just coming to the last order. My lord may see the last order, that is 23rd of February 24. My lord has it?
Yes.
Yes. Heard Mr. Endas and Mr. So-and-so, learned counsel for the applicant. Also heard Mr. A. M. Bora, learned senior counsel assisted by so-and-so. In terms of the order passed in IA number 87 of 24, list this matter on 19/3/24 with a direction to both the parties to proceed with the hearing on a fixed date without seeking further adjournment. Till then, interim order passed earlier shall be extended on the next date fixed and endeavor shall be made to dispose of the matter. This is how the matter has come up before my lords.
Okay.
Yes.
Item number 36.
37. Item number 37.
Now some IA is still pending.
Disposed, my lord. On the last
This
day it was
IA
so disposed.
1592.
It was disposed. No, that's a stay order, stay application. 1592. That is a stay application. I think that's a
Yes,
stay
now
application.
argue.
Basically, my lord, it's a dispute regarding the transfer of shares. Now, the complaint case has been initiated, my lord, by Mrs. Nilufar Rahman.
Who is the respondent in this case?
Yes, ma'am. She filed a complaint case, my lord. Now, the whole dispute regarding, my lord, one property called Rahman Property Limited, my lord. And for that limit purpose, my lord, there's a hotel called Dynasty, Hotel Dynasty. And the shares relating to basically pertaining to that Hotel Dynasty, man.
Okay.
Now, in this case, as per the complaint itself, my lord, I'll only rely basically that the all undisputed document, my lord, which is relied by the complainant itself, my lord, an uncontroverted document as well, my lord. Now, the complaint lordship will find at 140. And the and the lordship will find the cognizance order, that is the 171, last page, my lord. The cognizance was taken under section 420, 468, and 471 IPC.
420, 468,
68 and 471 IPC.
cheating, forgery, and using
Forged
false
document.
document.
Now, the complaint petition, my lord. May I read, ma'am? The complainant and the accused persons are members of the same family. Late Abidur Rahman, the husband of the accused number 1, and the complainant are brother and sister, and the accused number 2 is the daughter of accused number 1. Late Abidur Rahman, the predecessor in interest of the complainant, purchased the various properties in and around at Guwahati, either in his own name or in the name of his wife, Rumaina Rahman. Out of the state property, late Abidur Rahman, the predecessor in interest of the complainant, purchased a plot of land measuring 2 kotha 10 acre covered by so and so, so and so, so and so under Moja Guwahati at SS Road, Guwahati, together with the Assam type living house thereon, and thereafter the late Abidur Rahman demolished the Assam type house and constructed the 4-storied RCC building upon the said land, and the hotel business under name and style of Hotel Dynasty was started thereon, and since then the hotel business is running thereon. The ground floor of the said building, various shop rooms are there, which has been rented out of the same person. That the management of the entire property at Lakhtokia is known as Rahman Properties Limited, which is a private limited company. This is important, my lord. So admittedly, it is a private limited company incorporated under the Companies Act 1956, having its registered office situated in the hotel premises at SS Road, Lakhtokia, Guwahati. And that there are 4 members of directors of Rahman Properties Limited, and they were Abidur Rahman, since deceased, the husband of the accused number 1. He is the brother of the complainant, my lord. The complainant, then the one Sajid Haq, Maulong, then the accused number 1. So there are 4 directors at that relevant point of time now. 5. That the complainant holding now this is a private limited company, my lord. So here, lordship, I'll come back again. To the title page, lordship will find, though it's a private limited company, that company is not made a party here in this proceeding. Now again, my lord, paragraph 5. The complainant holding 2,26,500 numbers of equity shares in Rahman Properties Limited, but the complainant did not take any participation in the affairs of the Rahman Properties Limited because of the fact that the business was within the family members. Now, this is very important, Lordship, kindly mark this particular line. And it was looked after by late Abidul Rahman since deceased. Late Adilur Rahman since deceased, the brother of the complainant. So this is an admitted position, my lord.
Your husband looked after,
My husband
looked after
used to
the
look after
affairs
the
of the,
day-to-day affairs of the company. That is an admitted fact by her sister itself, the complainant. Besides that, the complainant being a director of the profession, a doctor by profession, is engaged with so-and-so hospital, healthcare so-and-so. So it was not feasible for her to take active part in the affairs of the Rahman Properties Limited. As such, the complainant always relied upon her deceased brother and after him upon the other accused person. After the death of Adilur Rahman, the entire affairs of the management of the Rahman Properties Limited come under the power and control of the accused number 1. This is also, Lordship, kindly mark it. It's very important. So admittedly, the after the death of my husband, as per the allegation is concerned, all the powers and control over the said my lord came to the accused number 1 after the death.
who is accused number 1?
I am the accused number 1.
You are.
Yes.
Okay.
Me, accused number 2 is my daughter.
You are Dr. Nilofer.
No, Ajana Rahman.
The complainant is doctor.
Nilofer is the complainant.
Okay.
So admitted position is that till my husband was alive, he used to look after the entire day-to-day business. And after his death only, I came into the picture, that the accused number 1 only, not even 2. The accused number 1 came into the picture as per the allegation in the paragraph 5. Then I used to look after the entire affairs and the management of the Rahman Properties Limited.
Yes.
The complainant had left some signed blank papers. This is also very important. The complainant had left some signed blank papers with her brother late Adilur Rahman on his request for availing loan for renovation of the hotel. So undisputedly, she has left some signed documents with her own brother during his lifetime. Yes. And now she said that this is only for the loan and for renovation of the hotel. That is her statement. That in the last part of the year 2014, the complainant could come to know that her shares in the Rahman Properties Limited were illegally transferred into the name of the accused person without her knowledge and consent. So the complainant, by later dated 2/4/14, made a request to the accused number 1 to retransfer the same in her name. As the complainant did not like to take the matter to unauthorized transfer of her shares by the accused person by falsification of her signature thereon, So the complainant offered to settle up the matter amicably to avoid the serious consequences of offense upon her own relatives. The complainant in her said letter detailed the number of shares illegally transferred by accused number 1 and accused number 2 in their names to be 2,18,100 and 8,400 respectively. The copies of the said letter is also sent to the other directors as well as GM Finance of Remand Properties Limited. Now, this is her claim that the share in my name.
Is this the main allegation?
This is the main allegation that 2,18,000.
Using the blank documents which she
That's
has.
not
ga-
very clear.
That is her case.
That is her case, my lord.
The blank documents which she
Yes.
gave to her husband.
Which has been subsequently used for the transfer of the shares to my name and my daughter's name,
Using her forced signatures.
using her post signature.
That is her allegation.
Yes.
Okay.
So I couldn't understand why the blank papers are necessary. If the papers are blank, why it is necessary to forge, my lord? Am I clear, my lord? I don't need to take a blank document for somebody.
Okay. It can be procured from anywhere.
Anywhere. Why she has to leave the blank papers to me that you use it whenever you require.
She
It
has
must
not
be signed.
stated that sign.
Yes.
Signed.
Yes, unless it is signed, it has no meaning at all. He says, I have left some blank papers. That's very interesting.
She has not stated that I have.
I have signed it.
Signed it.
Otherwise,
on
it's a-
blank paper.
Yes, it's not that her case, that they left some, it was signed blank paper, sorry. She has said it was signed blank paper.
Then the case would be different.
Yes. So she has said that it was signed blank papers, madam.
Yes, she has stated it
It
is
is
signed.
signed blank paper. So if it is a signed blank papers, then how it can be forged? I cannot forge it. If it is signed,
Signatures cannot be forged, but
Signatures
document
cannot be
can be
forged.
forged. Document may be
Yes.
made out.
the document may be, there is no allegation that the document is changed or something, because otherwise, document, there is no question of changing the document because it was blank. If it is blank, there is no question of any forgery.
No, using, I have not gone through the record,
No,
but
my lord, if I sign it in a blank paper, I can give it to somebody that use it for the whatever the purpose. He has used it for the purpose. So later on, I cannot say that this was forged because I have signed it voluntarily. He cannot only change my signature. The content is that the content was written in the blank paper. It was
yes,
only
but
for the,
that is perhaps not their case. Their case is perhaps
yes,
that I left blank signed documents which was used for some other purpose
which
for
is
which
meant
I
for.
was.
Which is meant for. He said that it was meant for only loan purposes. madam.
Yes.
But to that effect, there is no material. That it was only for loan purposes. Now, anyway, my lord. Now, so admittedly, it was a blank signed paper. Now, paragraph 7. The complainant got reply of the said letter from each of the aforementioned person. The accused number 1 in her reply dated 16/12/14 admitted the transfer of 2,18,100 numbers of share of the complainant in her name and 8,400 numbers of share in the name of accused number 2. But the accused number 1 stated that the transfer were made by late Adilur Rahman, her husband, during his lifetime by making payment of the due consideration. So admittedly, my lord, we have said that the yes, shares has been transferred to our name and to my daughter's name also. But our case is that this transfer had happened during the lifetime of my husband. The rest of the parts may be disputed, whether the husband paid or not paid. I'm not going into that detail. My only concern is here that admittedly, my lord, this had happened during the lifetime of my husband. The other directors have in their reply denied to have any knowledge about the such transfer of such shares. So this is very important, my lord. Now, who are the other directors, my lord? Let you kindly mark it again.
Two other persons here.
One is me.
There were total 4 directors.
That is 4.
Husband died.
Husband died.
One is
She is complaining in one. One is me.
another.
Another one is the one more person, my lord, Maula. So this is very important. The other directors reply denied to have any knowledge about the such transfer of the shares, which is relied. The complainant begs to state that neither of the complainant did receive any consideration of her shares to transferred or nor the same were transferred by her. So the complainant by another letter dated 25/7/15 requested the accused person for amicably settlement of the illegal transfer of share by saying that if the shares of the complainant are not retransferred in her name, the matter would be taken before the court of law for necessary action for wrongs so committed by them, by the accused person did not pay heed to the such request. So in the paragraph 7, the one apparently one thing is very clear, that the other directors had no knowledge about the transfer of these shares. That means me. I had no knowledge at the time regarding the transfer of the shares. Now the paragraph 9, that is the most important paragraph here. Now how they have made out a case, I'll show. That it may be pertinent to mention here that late Adilur Rahman, the husband of the accused number 1, died on 13/11/2012. Lordship, kindly note it down. He died on 13/11/2012. The shares of the complainant were transferred in the name of accused number 1. Let us first see when it was transferred in accused number 1 as follows. Number 1.
After the death.
No. 5/11/2012, the first one, period. 5/1/2012, my lord.
And 7/12.
7/12 will come, my lord. 5/1/2010, Nalipur Rahman to Afroza Rahman, that is accused number 1, that is the share 2,18,100, my lord. So these share was transferred prior to the date of the accused husband.
Of the accused.
Because he 10 months. So prior to the date of the accused number 1's husband, 10 months. 10 months prior to the date, it was already been transferred, admittedly. There is no dispute at all. So admittedly, it has transferred at that relevant point of time when my husband was alive and when he used to, as per their own king, when he only used to look after the day-to-day management of the company till his death. Till then, we are not nowhere in the picture. Admitted fact. So if something has been done,
It is
it is
not
done at that relevant point of time. So that's not disputed. Now, this is absolutely wrong, my lord. The second one.
No, is it your submission that, just to understand, that as it was, transfer was during the lifetime of your husband, 11 months prior to his death. Therefore, if there is some wrongdoing,
Yes,
it
absolutely.
is not
Yes.
you, but
I cannot be
it may be
criminally
somebody else.
liable, make liable for the, if any offense has been committed by my husband. And
Because the documents were left with your husband only.
yes,
Blank documents were
if
not.
that is also left to husband, and the admitted position is that during the entire lifetime, he used to only look after the day-to-day management of the company. There is no allegation that apart from the husband, that I and my daughter also used to run the business of the company. There is no abatement to that effect, my lord. No statement, nothing. There is clear statement by the complainant that our own elder brother, he used to look after the day-to-day management. And apart from that, they've also said, they said in the statement that the other directors, that means the accused number 1, had no knowledge about the transfer of the shares. That is also admitted fact. Now the second one, my lord. Second one, what they are trying to say, my lord. The second transfer, that is the 8,400 to my daughter, that was post to the date of my husband. Because as per their allegation, it was transferred on 7/12/2012. My husband died in 13/11. In the same year, in the month of December, he died in the November. In the December, on 7/12/2012, it was transferred to the accused number 2. I'll come to that now. Number paragraph 10. That the complainant begs to state that accused number 1, with an intention to hide her sin of falsification and the forgery, has been showing the name of Adilur Rahman for transfer of share in her name. But the fact remained that the shares were transferred in the name of the accused person. So the accused person are the guilty of the said illegal transfer of the shares and for doing the forged the signature of the complainant. Besides that, 8,400 numbers of shares were admittedly transferred after the date of the Abdulur Rahman. So for the said transfer, the accused person have so space for their explanation, madam. Madam, this is a contrary to the other statement, madam. Because I was not in the picture till the date of my husband admittedly in the previous statement. All the previous statement, I was not even in the picture. Now 11, so this is the prayer, my lord, basically. Now, Lordship kindly, there is the relied document. Now, Lordship kindly turn into these transfer. When the transfer had happened, my lord. First, the page 17. Lordship kindly turn into page 17. This is uncontroverted document, my lord. And this is the document where he said that her signature was forged. Lordship got it, page 17, please. Now this is, Lordship kindly see. First off, the number in figures, description of the equity preference shares, number in figure is 2,18,100. Has your lordship got it?
Yes.
That is the number in figure. 2,18,100. So this is the prior allegation. This is admittedly, my lord, this transfer had happened to accused number 1 prior to the death of the husband. So the date, lordship kindly see, lordship will find the date here. It is on the 5th January 2012. Five one 2012. This is admitted position, my lord. They have also admitted this part, my lord. Now, lordship kindly see when it was submitted, when it was presented in the upper part, there is a seal, my lord. Lordship will find that it was presented to the authority under the 108 of the Companies Act, my lord. It is on 18/1/2012. It was also presented, as your lordship got it, that seal, my lord. Yes. Seal of the authority. Seal was on 18/1/2012. So, not only it was transferred, but even this was also presented to the authority for the transfer during the lifetime of my husband. So admittedly, if this is the forged document here, he said that the Niloufar Rahman, the signature here, is not her signature. Now, one more factor, lordship will kindly consider, my lord. There is no allegation in the avertment, in the complaint petition, that the signature which to the transferee, here also lordship will find the signature of the transferee or the buyers in particular belongs to me, my lord, or Afroza Rahman. Am I clear, man? There is no allegation to that. Only allegation is that her signature in this form is not. It's a forged one. But there is no allegation regarding that I made the accused number 1 also sign in that particular paper. No allegation to that effect. Though this share has been transferred in my name. Now the next one, my lord, this is the more important. The next one, the lordship can read page 21. Now, what was her allegation, my lord, in the complaint petition, in the paragraph 9, lordship will see how they have manipulated this, my lord. Page 143. The second one, their allegation is that the second transfer had happened after the death of my husband. It was happened on 7/12/2012 to the daughter, to my daughter, 8,400 numbers of share. Now, lordship kindly see page 21. Now, again, lordship can kindly see the number of figure here, 8,400. Now, date lordship will find here, again, dated is 5th January 2012, place Guwahati.
This is this document she has annexed with.
Yes,
complaint.
yes, yes. They are admitted document. These are all admitted documents. Then again, this also document all same day, it was submitted on 18/1/2012. Lordship will find the official signature seal here, same day. So both the transfer, both the share to me and to my daughter was signed on the same, on 5th January 2012, and also been presented to the authority on the same date, 18/1/2012. Not whatever they have alleged in the paragraph 9 to make out a case, my lord. It is contrary to their case, my lord. Their own document. The document says it was created on 5th January and it was presented on.
Who have in this criminal petition challenged the cognizance taking order.
Yes. Along with the whole quashing of the
conflict. What are the grounds?
This is the basic ground, my lord. The first of all, the company is not a party here. Secondly, admittedly, the document which they have annexed, their main allegation is that it has been created by me after the death. Whereas the contrary is that in the one paragraph, in the previous paragraph, it was said that it was been created during his lifetime and then presented and the transfer had happened in our name. But in the paragraph 9, to show that it was a forge, it can't be transferred, it has not happened during the lifetime of the husband. They have made a statement in the paragraph 9 that this transfer had happened by the second share in my daughter's name. It was on 7/12. After the death of my husband. So to create an offense, my lord. But the document says otherwise. Their own document, and it is an also, apart from that, this is an uncontroverted document. This is not even my document. It's a file on the authority concerned, my lord.
It does not support the statement made by the complainant in para
9. Okay. And it is an uncontroverted document. So it now, now Lordship kindly turn, Lordship kindly take up the LCR. The initial deposition of the complainant will clear everything, and the statement of one of the star witnesses of the complainant, what they have said, madam. That will seal everything, madam. Now, the initial deposition of the Nilufar Rahman, it will clear everything, my lord.
Page.
Lordship kindly take the LCR, my lord. Lordship, LCR. Because it was not initially annexed to the our petition, my lord. LCR to mark করে বলেছিল নো পাহাড়ে বলে
CR case 2040. What was the CR case number?
CR case number, my lord, 2040. 15.
At what state? Now, what is the status of that 2040? It has been stayed.
That has been stayed.
At what stage?
After the evidence has been recorded, because this is the case of the warrant procedure, my lord. Their initial deposition of complainant has taken and the prior to the cognizance, my lord, statement of the court witnesses also been taken.
It's here of 2040.
Yes, ma'am. If lordship permits me, I'll try to find it out.
No, I got it. Nilofer Rahman.
Yes, Nilofer Rahman. Nilofer Rahman, my lord. May I read, my lord?
Yes.
মই এই গোচৰ আফরোজা রহমান সিস্টার ইন ল নিস আরজানা রহমান Sajidul Khan, director of the Dynasty Hotel.
No, where are you reading?
The initial deposition, my lord.
Of Nilofer.
Nilofer.
মই আসামি গণক চিনি পাওঁ।
No, that is probably the his deposition, my lord. Subsequent.
Okay.
Date to now.
4963. 4963.
It was dated 4/9/15, my lord. That initial deposition was recorded. May I read, ma'am? Has your lordship got it, my lord? Initial deposition.
Yes. My Gosar Afroja Rahman.
Yes, my Gusar Afroja Rahman, sister-in-law, niece Arjana Rahman, Sajidul Khan, director of the Dynasty Hotel. মই হোটেল ডাইনেষ্টিৰ আমি ডিৰেক্টৰ আছিলো আৰু মোৰ নামত 2,26,500,202 শ্বেয়াৰ্স আছিলে মোৰ দাদা লেট আদিলুৰ ৰহমান নে হোটেলৰ এফেয়াৰ্স চাইছিল this is important my lord again admitting who was looking after my lord the deceased husband.
Yes.
মই বিশ্বাসত সকলো দায়িত্ব তেওঁক দি দিছিলো যোৱা 13/11/2012 মোৰ দাদা ঢুকায় মোৰ সিস্টাৰ ইন লয় তেতিয়া সাকসেশন সাৰ্টিফিকেট এপ্লাই কৰিলে তেতিয়া ময়ো হোটেলৰ শেয়াৰ এটসেট্ৰা কথা জানিবলৈ ৰেজিষ্টাৰ অফ কোম্পানীজৰ ষ্টেটমেন্ট ললো কিন্তু গম পালো যে মোৰ নামত থকা 2,18,100 শ্বেয়াৰ্স মোৰ দাদা ঢুকুৱা আগতে this is important my lord মোৰ দাদা ঢুকুৱা আগতে মোৰ সিস্টাৰ ইন ল আৰু কমা Arjuna Rahmanor namot transfer hoi jay. So this transfer had happened prior to date of my husband. Now again, let's go back to paragraph 9. What they had said in the paragraph 9?
The daughters is
Yes.
after the death.
After the death. But here in the statement, her categorical statement that the shares already been transferred to our name during the lifetime of my deceased husband. So why they have made this paragraph 9 actually? Just to show it to the court that this has happened after the death of the husband of the accused number 1. So this is a falsified document. It can't be. So just to, they made a false statement on oath on the complaint just to make out the case, apparently. Contrary to their statement and the oath. In the paragraph 10, they have categorically again said that the burden on me, that how it had happened. So there other, again, they are stressing that it was share has been transferred after the death of my husband in the paragraph 10. 9 days said the table when it has been transferred. 10 they are again saying the transfer has been held during after the death of the accused, my husband. Paragraph 10. Whereas in the initial deposition, this is absolutely contrary to the complaint. So rather, in this case, they are liable to be charged for making a false statement before the court under 340, my lord. Proceeding should have been drawn against her for making this false statement at that initial point of time. But fortunately for them, I was not the counsel at the time in the trial. I'm reading again. কিন্তু গম পালো যে মোৰ নামৰ ইমান শ্বেয়াৰ মোৰ দাদা ঢুকুৱা আগতে মোৰ sister in law so and so নামত ট্ৰান্সফাৰ হৈ যায়। বেলেঞ্চ 8,400 শ্বেয়াৰ্ছ মোৰ দাদা ঢুকুৱাৰ উইদিন 3 উইকছৰ ভিতৰত মোৰ নিজৰ নামত ট্ৰান্সফাৰ হৈ যায়। এতিয়া ডিসেম্বৰ 2004 মই মোৰ sister
Here he is making statement.
yes, now again he is making another statement, madam, which is contrary to the whole one. তেতিয়া ইমান তাৰিখে মই মোৰ sister in law বিষয়ে জনাই এখন মই চিঠি দিওঁ। I'll come to that চিঠি, madam. And the settlement কৰাৰ বাবে জনালো। ট্ৰান্সফাৰৰ কথা ৰিসিভ কৰিবলৈ ক'লো। এইবোৰ কৈ যাওঁতে তেওঁক ডিটেইল দিগদাৰ নকওঁ। ইন দ্য মিন টাইম আকৌ সেকেন্ড লেটাৰ দিওঁ, কিন্তু বেসলেস এলিগেশন বুলি কথাটো ইগনোৰ কৰিলে। মোৰ কনসেন্ট নোলোৱাকৈ শ্বেয়াৰ চাৰ্টিফিকেট কৰিছে, কোনো পেপাৰত সাইন কৰা নাই। মই মোৰ দাদাক কেইখন ব্ল্যাঙ্ক পেপাৰত সাইন কৰি দিছিলো, কাৰণ তেওঁ লোন আৰু হোটেল ৰিনোভেট কৰাৰ কাৰণে সেইটো লাগে বুলি কয়। মই বিশ্বাসত সহি কৰি দিওঁ। Now, this is her statement. Now, there is one PW, sorry, my lord, CW 2. Dated, my lord, 14/10/15. This is very, very important document.
Ramina. What is her name?
Ramina Raman,
Ramina.
mother. And it is their witness, my lord. This is the most important statement here, my lord. The complainant Niloufar Rahman, মোৰ ছোৱালী হয়। তেওঁ এই কেছ আফৰোজা ৰহমান আৰু আজানা ৰহমানৰ ওপৰত কৰিছে। আফৰোজা মোৰ বোৱাৰী হয়, আজানা মোৰ নাতিনী হয়। মোৰ ডাঙৰ ল'ৰা আবিদুৰ ৰহমানৰ নামত আৰু নীলুফাৰৰ নামত প্ৰপাৰ্টি শ্বেয়াৰ্স আছিলে। নীলুফাৰৰ নামত 2,26,500 শ্বেয়াৰ্স আছিল। এই শ্বেয়াৰ্সখিনি this is important. এই শ্বেয়াৰখিনি, Lordship, kindly mark this portion. This is the main crux of the whole case. এই শ্বেয়াৰখিনি আদিলুৰে ঢুকুৱাৰ আগতে 5/1/12 আফৰোজাৰ নামত ট্ৰান্সফাৰ কৰি দিলে। That's all. Who did it, my lord? Who has transferred, my lord? their own witness, that my husband during his lifetime on 5/1/2012, he has transferred it in the name of accused number 1. So admittedly, my lord, their case that the deceased prior to his death, who is looking after the day-to-day management of the company, he has transferred the entire share in the name of accused number 1 and in the name of accused number 2. নীলুফাৰে কোনো কনসেন্ট এই ক্ষেত্ৰত দিয়া নাছিল, কিন্তু পিছত গম পালো যে মোৰ ছোৱালীৰ পৰা ব্লেংক কাগজত আদিলুৰে চহী কৰাই লৈছিল। So admittedly, as per this statement, that signature is not forged. Yes, that signature is not forged. It was her signature. Consent is not given, that's a different issue. But the signature is not hers.
Signature was given on the
Blank paper,
but
which he has converted for the transfer of the shares.
share transfer form were printed form.
My lord,
The share transfer form
is a printed form.
is a printed form. It is
But
not-
that is their case. They have not explained it that this is not the form. This is something else.
Whether they have denied that the.
No. That's not
that
their
this-
case at all.
This is mine,
Yeah,
not my
no.
signature.
They have, they all have said, she has also said that I have signed in the blank papers.
Which has been converted in.
This is in a converted, the CW1 also said, this has been probably converted for the transfer of the shares. CW1. She also said, I have signed in a blank paper. This might have been converted for the purpose of transfer of the shares. This is in dispute, my lord. Neither goes here and there. But the fact remains that it goes in favor of the accused when it is not conclusively proved. Because in the complaint page, they have to make out a case specifically.
That the signatures are. forged.
Signatures are forged, and these signature with the certificate, the share transfer form, where my signature appears, are forged one. Rather, they have
But in their complaint petition, they have
mentioned, somewhere they have mentioned
the signatures are also forged.
signature are also forged, but again they have said that we have signed these blank papers. Why? These two contrary stand, my lord. There's no necessary to say this part, my lord. That there's signature taken in the blank papers. If the signature was forged at all in the transfer certificate, that's enough, my lord. That this is not my signature.
But that may be a fact which they want to bring it.
Maybe, my lord, maybe. So they have not cleared it. That's what I'm saying. They have not cleared it. It's created doubt in their case itself. It creates a doubt in the clear itself. Sometimes they want to make it a case that these signature, that I have signed some blank papers, they might have used it for the purpose of transfer. And someone again, they have said that my signature does not, it's forged one itself. But the fact remains, one fact is remain, whatever may be from this deposition and the complaint case itself, two things is apparent. Their own case is that this has happened during the lifetime of the deceased, and the CW2 in her statement before the court, their own witness categorically stated that who had did it? It was by my deceased husband. Now, who is liable for that, my lord? If it is a forgery has been committed, I cannot be liable for that forgery because I didn't. Now, whole case, lordship kindly see, their whole case is what, my lord? The accused, my husband, till his death, as I said before, till his death, he used to look after the day-to-day affairs of the management. During his time, it was submitted to the authority concerned all to this document for the transfer. He did the forgery.
Therefore, this date is important, 18/1/2012.
Yes. During his lifetime.
When it was presented before.
Yes.
Registrars of. companies.
Yes, companies, during his lifetime. And forgery was also made during his lifetime by him himself, as per their own statement. So this is not a case of 420. 420 doesn't arise here because there is no inducement by me that you signed it, then I have falsified. 420 does not come at all. Initial deception is no, not a avertment also. There's a, I had initially induced her to sign it, then I have forged the document, then I have used it for the transfer. It is not the case of 420. It can't be 420. There's no allegation of 420 or any material of 420. It's a case of simply forgery of the document. Now, their witnesses said that who has, if it is at all forged, who has did it? My deceased husband. He forged it, he presented it during his lifetime. And their categorical statement also, the other directors, including me, are not aware of these transfer. That is their also statement in the complaint. Now, again, the Lordship has seen to make out a case, they have changed the date in the complaint petition in the paragraph 9 regarding the transfer of the shares to my daughter. Now kindly see again, Lordship, come back to that page, page 21 probably. The share which has been transferred to my daughter, page 21, even in that, even there is no, my signature does not appear, my lord. The daughter's signature, page 21, Lordship kindly see. It was signed on behalf of my daughter by somebody else. It is for so and so. Rahana, Ajana Rahman.
Who has signed it?
There is no allegation to that effect who has signed it.
Okay. Otherwise, this document was also presented to registrars of companies. Before,
Yes.
Before
On the same day.
Death of your husband.
Yes, on the same day. Both the share transfer form has been submitted on 18/1/2012. Though they have said it was post, it's not the correct statement in the paragraph 9. And my signature also does not appear. Even the accused number 2 signature does not appear. Somebody else has signed it on behalf of accused number 2. And even in 1917, in that particular document, there is no allegation to that effect that the signature of Afroza Rahman been signed by the accused number 1. And Lordship kindly see, there one more interesting fact. The occupation here in the form 17, the page 17, the occupation of the Afroza Rahman is a housewife here.
No. Afroja or Nilofer?
Afroja. Housewife. Has your lordship got it?
You are Afroja.
Yes.
You are a doctor.
No.
No.
Afroja, no.
The Nilofer
Nilofer was a doctor. He is a complainant. Paragraph 17. My occupation, lordship will find in the occupation column, the purchaser, the buyer's particulars, my lord. My occupation was shown as housewife. Whereas they are claiming that I am one of the director. And there is no single abatement in the whole complaint. that I was one of the signatory of this particular purported forged document. In first share transfer of 2 lakhs, my lord, and in the second, admittedly, in the second transfer, my lord, the accused number 2, my daughter, is not the signatory even. And she's not a director also. In her case, the occupation is a student. Now that being the position, my lord, now again I'll come to the letters now. Now they have also filed a civil suit, my lord. This is also uncontroverted document. The civil suit I have relied in my document because this is an uncontroverted document. They have filed a civil suit. In this civil suit, my lord, there is no allegation.
Civil suit for cancellation.
Yes, my lord, this transfer. That lordship will find page, page 92 onwards.
Page 92 of the petition.
Yes, ma'am. We have also annexed all the checks
No, this
which
is
has been paid to the complainant, but I am not going into that dispute, my lord.
This is a dispute, property dispute, not
Yes.
relating to shares.
Yes, lordship kindly see here. Here the share is the question of that particular case, my lord.
In civil suit also,
Yes, yes.
all equity shares. Page 98.
Yes. Page 99 also lordship will find.
Page 99, all equity shares.
99, yes. All equity shares of Rahman Property. Apart from that, my lord, this is a case. Here, not a single line, my lord, lordship will find that there is a forgery of this particular document, my lord. Just to make out a criminal case, just to pressurize us for the compromise. So this is the criminal case has been initiated. Initially, there is no allegation of the forgery. Now, she has admittedly written two letters to me, my lord. In those 2 letters also, which is admitted by her, also been exhibited, also been by them, those 2 letters, there is not a whisper that we have forged the document.
Where are those letters?
Yes, ma'am, welcome. I'm coming to those letters, my lord. The second letter, lordship kindly see 152A. And the 144 is the first letter, my lord. Just after this is the Now, Lordship, see this later how it is contrary to their whole case. It has come to my knowledge, this is on 14 itself, that the shares I holding in the Rahman Property Limited has been transferred to Ms. Afroja Rahman and Mrs. Ajana Rahman, name without my consent. For your ready reference, I have given the details of the shares transfer without my consent. This is the same from 2007 to December 2013. The transfer period. Now, transfer period apparently 2012, not 2013, my lord. The document says it is 2013 to 2012 transfer period. Now they said in 2013. As you were aware, this is a serious offense. And
One query,
my lord,
the share transfer form which you have shown
yes,
at page 17 and
17 and
21,
21.
whether it contains transfer of all shares.
Yes,
please
yes,
mention.
which has been alleged, my lord. That's
No-
why I'm
no
saying.
other share transfer form is there. By this.
Yes,
share
yes,
transfer
yes,
form,
yes. The amount of share, that is the one, Lordship will
All-
kindly see the figure.
21,
Number one is 21 lakhs,
21,000.
22 lakhs, 18,100. And other is 8,400. And in the certificate also, the transfer form and so, that will indicate, my lord, their whole allegation. These are the only two documents, my lord. And the mother, Lordship, in the mother's the deposition, she has given the calculation of the total share. That also relate to this, my lord. 22,600, 500. 2 lakhs, 26,500. So total, my lord, whatever they have said. The mother, CW2, Lordship kindly see, the mother's statement, if you add on, that's why it's very important, my lord. Lordship, I'm reading again the mother's statement.
Yes.
নীলুফাৰৰ নামত 2,26,500 shares আছিল. So this is the total figure actually. If you add, because Nilufar actually, she is having the 2,18,100. Sorry, man, Afroja. Transfer to Afroja is 2,18,100 and to Arjana 8,400. Arjana, daughter, 8,400. If you Lordship add, it will comes into 2,26,500. 2,26,500. Now, what she said, Nilufarar namot 2,26,000 iman toka 5 share asil. Now, next slide is right. A share kini, that entire share. The entire share. That's very important. The A share kini adilure dhukwar agote 5/1/12 Arjanar namot transfer kori dile. So her own son, before his death, has transferred the entire share in the name of the accused person. Yes. Entire share, my lord. And the date is also very, Lordship kindly see, Dhukwar Agot 5/11/12, the admitted fact. The document also said 5/1/12, which we relied on. So the shares got transferred on 5/11/12. There's no dispute. They can't create any dispute now. Because their own document, their own statement is 5/11/2012. Whereas they are in the paragraph 9 is stating something else just to create a case against us, my lord. Now, again, my lord, this 144, my lord. Later, I'm coming back, my lord. As you are aware, this is a serious offense and you are given 15 days time to rectify the unauthorized transfer and the falsification of my signature on shares transfer done by you. Now this is done by you and the company. Now she has alleged the company also. Please note that I don't want to take any legal action without giving an opportunity to rectify the status of the shares holding pattern prior to 2007 status. I hope you will take the opportunity to resolve the issue amicably. Rectified status and the same need to be provided to me within 15 days time, my following address. So now what is said that this is period is 7 to 13, which is a false statement. Then she said I have transferred the shares. It's also not correct because the CW says it is during the time of the husband, and who did it? The husband also. Now Lordship will find the next letter that you will find at page 152A. The second letter from me. I hope this letter finds you in the good health. This reply was long due and the delay is due to my kids' exam and so and so and so. Anyway, the earlier letter was regarding the falsification of my signature to transfer my shares in Raman Properties Limited to you and Arjana's name. Now, he has said it was transferred to you and Arjun. I maintain that I never been informed about the board meeting of Raman Properties Limited. I never attended any board meeting Raman Properties Limited. I have not signed any share transfer form, have not transferred my shares to anyone. My shares in Raman Properties Limited has been transferred illegally by falsifying my signature. You have mentioned in your letter to me that the shares were transferred during my late brother, Adilur Rahman, tenure as MD of the company. It may be so. This is important. It may be so. Admitting money. That still does not make the shares transfer illegal. So she's admitted that it may be so. It may be transferred during her brother's lifetime, but it is. So what is the case, madam? The allegation against her own brother, who has illegally transferred, falsified the signature, forged the signature, and transferred it to our name behind our back. Because she has also claimed in the petition that I have no knowledge about the transfer of the shares in the complaint. So how we can be made liable for the offense committed, alleged offense committed by my father, the late husband? Maybe it got transferred. So you have filed a civil suit. No issue, my man. If it is proved that it has been illegally transferred, the forgery has been committed, definitely you are entitled. But whether we are liable, our case is that. Our case is limited to that. Because from the reading of the complaint and the annexures, does not make out any case against us. Simplified manner. The statement of the mother has categorically sealed the entire case, madam. She has specifically said that it was done by the late Adilur Rahman. And it was transferred although during his lifetime. So how they can make liable for forgery of document? And moreover, the fact remains that we are not signatory, there is no avertment to that effect, that we are signatory to that effect, those share transfer form. I have not signed any share transfer form during his tenure either. It is your responsibility now to sort out the issues since the share has been transferred to you and Arjana's name. If you continue to hold the shares in spite of knowing that they have been transferred illegally, then you will be held responsible. From this letter, it appears that she was aware, she is also admitted that it has been falsified by the late brother. Her only allegation that we are still holding the shares in spite of knowing that fact that it has been illegally transferred. So we are criminally liable for the forgery. Whereas even her own statement in the complaint petition said that till the dates, we are nowhere in the picture. He used to look after the entire management. Again, she said, nobody, I was not even aware of the share of the transfer. No directors are aware of the share of the transfer. So I am the director, my lord. My daughter is not even a director. Her own statement that I was aware, not aware even the transfer. So there is no question of using that forged document, knowing it to be a forged one. And there is no avertment to that effect also, that your husband, that is very important, madam. Your husband has created those documents and you are aware that these are the forged documents. To that effect, no avertment. That your husband has created those documents during his lifetime, transferred the share to your name and your daughter's name, and you are being a director, you are aware of the fact that this was not my signature. Still, you are holding that. Then it may be a case that knowing fully well this is a forged document, even then I am using it for my own benefit, then the 471 comes. But here, that avertment is missing. We cannot assume it now. There is no material to that assume it also. Whereas it is contrary to that, they admitted that not even a single directors are aware of the fact that the shares has already been transferred. Only after when I had applied for the succession certificate, they came to know that the shares got transferred. Our shares got transferred. As for the question raised by you in your letter as to rely, I have taken more than 2 years to put this allegation against you. My answer is that only after you file the succession certificate and after receiving the notice dated so I inquire about my shares in Raman Properties Limited, and to my utter horror, I found that all my shares were transferred in you and Arjana name without even signing the shares transfer form, and there's even I wrote to the others. I don't want to distress you, Arjana, and nor 150 employees of the company as you have accused me of. All I want to clear the issue amicably. My signature in is my identity, and it fills me that with the fear and insecurity as to where else it may be used. Misuse. Please do not consider this is a baseless allegation. Falsification of signature is a serious criminal offense. I hope good sense will prevail and that your decision will protect not only the company but also the employees. Me and my family has always supported you and will continue to do so. You have repeatedly rejected our gifts and offers of help, but we will continue our duty as a family in spite of the insult. So she used. I'll continue in the next date, madam.
When will you?
So basically convenient for my lord to have it fixed on 4th of April.
4th of April.
I mean, no issue. 4th April.
Lordship, just.
Okay. Mr. A. M. Dora, Learned Senior Counsel, assisted by Mr. A. Bora. A. Borua, Learned Counsel for the petitioners. Also heard Mr.
And thus,
Learned Counsel for respondent. One, you are for
I have for both the.
Both these.
For the complainant, respondent number one.
the respondent number 1 and 2. State is.
Respondent.
Also
This is
heard
just a
Mr.
formal party, madam.
Mr. K. Bosho, appearing for the state respondent. The hearing remain inconclusive. Fix this matter again on 4th April 2024 as part of.
Fine. Please.
Obligation.
May I seek my lord's indulgence if it may be fixed for a particular time? I'm coming from Delhi, I'll accordingly plan my schedule, subject to the convenience of my
Subject
learned.
to my convenience because there's other cases also. I can't,
No, we are
right now it will
fixing
be
it on
difficult me.
4th.
It's
It's
fourth.
4th.
It's coming on fourth. I'm not,
On
no
that
objection.
day morning, you may mention if you require some accommodation.
Yes, yes.
On 4th morning, somebody may mention.
Yes, yes.
So obliged.
Others are left over.
The date may be fixed.
No, it will be rolled over. Registry will fix it. Also.